Thank you, Ashley and Aslan Creative, for hosting and organizing this meeting. I would want to extend a very warm welcome to the people, the experienced mediators who've agreed to prepare and provide orientation and training for this project. Our first speaker will be Sheena Jonker, who is the head of ADR Network SA. The second speaker will be Advocate Michelle Posman, an advocate and mediator from KZN. And the third speaker, Advocate Ian Dutton, who is an advocate and mediator also from KZN and who runs the Prac Guide website and service. After those three formal and introductory lectures, I'm going to invite the mediators and observers who have been participating in the first round of 6 RAF mediations to give comments on their observations and their tips or recommendations for the way going forward. And after that, we will invite comments and questions. The program for today has been scheduled with Aslan for a 3-hour program, but we intend to complete all the necessary training and formalities within the first 2 hours. So anybody who wishes to leave after 2 hours is welcome, but I will remain for the 3rd hour, and anybody else who wishes to remain for the 3rd hour is welcome, so that we can deal with further questions, comments, recommendations, and general discussion. So just before I introduce Sheena Jonker, let me tell you that this is intended as not a motivational discussion or a recruiting discussion. This is meant to deal with the crucial things of you are an accredited mediator. Now you're going to participate in an RAF mediation pilot project. What exactly are you going to do, and how are you going to deal with and overcome some of the difficulties that will obviously arise? So the first thing I would like to describe is exactly what the participants are, who they are, and what their roles and responsibilities are. Janae has prepared a document which we will publish. We may find that we adjust that document a little bit during the course of today's training session, but at the end of it, we will publish that document for everybody to refer to. That is called the roles and responsibilities of the mediators and observers. So let me just go over that so that you've got a feeling of where you will fit in and how you will progress in this process. The mediations from SOMLA's side are set up as teams of 4 people. They are identified as a lead mediator, a co-mediator, and 2 observers. We try as far as possible to keep a 50-50 balance between people from a legal background and people from a medical or healthcare background in the selection of those 4 in the team. Sometimes that's not possible, and we make adjustments according to certain principles that we think work. But every member of that 4-member team has got a very important role to play. So there's not a thing of observing passively and not contributing. As an observer, what it means is you don't talk while the parties are present. So when the parties are in the mediation, only the mediator and co-mediator talk. However, periodically during the course of a mediation, at his or her own initiative, or at a request from an observer or co-mediator, the mediator can say, right, we are all going into breakout rooms, and I'm going to go with the co-mediator and 2 observers to our breakout room to discuss. And at that point, you are free to ask questions, to make recommendations, to criticize, or whatever. So we value your inputs on your observations and your recommendations. But the observers do not make any recommendations or contribute in any way while the parties are present, because they have agreed to have a mediator and a co-mediator and 2 silent observers. The other important duty of the observer is to record what happens. And that happens in two phases. The first is in the pre-mediation meeting. One observer will maintain the minute. In the mediation itself, the other observer will maintain an observer report. Michelle will tell you more about that. The mediator is responsible for everything that happens. So apart from his or her own responsibilities, it is the responsibility of the mediator to maintain the proper standard of the mediation, to ensure that all participants do the right thing, and also to make sure that the research imperatives of this project are carried out properly and timeously. Just in terms of organization, we do have difficulties with one person, i.e. Janae, who is my practice manager, organizing everything and sending and receiving thousands and thousands of emails. So the process we've identified is the following. We have already set down dates for the next 24 mediations. And they will be on Mondays, Wednesdays, and Fridays by arrangement with the RAF. I have drawn up a schedule of 7 teams who will do those mediations, which I will show you later. And you will just be allocated according to the sequence in that schedule to the next date. Janae will then provide everybody with that information. So you will get information about the team that you're in and the dates that you are scheduled for. On receipt of that, it is the responsibility of the lead mediator to, first of all, own a Zoom Pro license so that you can run a mediation. Secondly, then to create the Zoom meeting on your license for that date, and to ensure that you invite all the necessary participants to your Zoom meeting. That is the co-mediator, the 2 observers, the plaintiff attorney. If the plaintiff, him or herself, is going to be at a different computer, then also the plaintiff and the RAF. So the mediator has to create the meeting on Zoom and send invitations to everybody. The mediator also needs to confirm with the observers and co-mediator that they are going to be there on that date. Because if any of them is not able to be there, they need to report that to the mediator, who will then need to contact me to work out what to do about that. But as far as possible, to make this thing work, I must request everybody to try, as far as possible, to make yourselves available on the scheduled dates. And that's also why we are giving out those dates now well in advance. Then the mediator will open the meeting and everybody will join. The mediator will then, on the one hand, run the Zoom meeting, so host the meeting, and the mediator will host the mediation. The co-mediator doesn't have any particular duties before the mediation. Inside the mediation, the co-mediator is responsible for seeing to it that all documents are properly completed. One document, the pre-mediation, the agreement to mediate, must be completed and signed by the co-mediator. The other documents will be done by observers, and so the minute of the pre-mediation meeting, observer report will be done by observers, and the settlement agreement will generally be drawn up by the plaintiff attorney. But it is the responsibility of the co-mediator to see that all those documents are completed and done before the meeting ends. And if the mediator, for example, loses track and wants to end the meeting, the co-mediator must say, no, we still have to check that document. Then, when the documents are completed and the recording of the documents is, the agreements is completed, documents will be sent in a sequence that is predetermined, and they must all end up at the co-mediator. And then if the co-mediator must keep track of that and make sure that you have received all 4 documents within a few days' time. And any documents that you haven't received, you must then please follow up and see where it's stuck and ask whoever to send it. So the co-mediator's biggest job occurs with documents during the mediation, and collection of documents after the mediation. So if everybody plays their part right, they'll all end up in your email within a few days. If they don't, the co-mediator will chase up and obtain them. Then when the co-mediator has all the duly completed and signed documents from that mediation, he or she will send them all together to the SAMLA coordinator, which is Janae, who will then file them in the proper secure place and provide copies to the RAF. So that is just a brief overview of the administrative roles and responsibilities. So with that, and without further ado, I would really like to thank Sheena Jonker, who is, in mediation terms, I would say almost like my grandmother in terms of experience. And we are really thrilled that she is bringing all of her wealth of experience to this project. We know that in RAF mediations, their character is different to other types of mediation. Particularly in the medical sense, it is different to the type of problems that occur in clinical negligence mediations. But nonetheless, there are wounded people, and there are people who are scared, there are people who are distrustful, there are people whose egos are a problem for them. So the trouble is, even in an RAF mediation, personalities, egos, and emotions play a role. And Sheena is very thankfully going to tell us how to deal with that. Sheena, over to you.
Thank you so much, Dr. Edling. It's really an honor to be with you this morning and to be talking to everybody. So what I'm going to be doing is I'm going to be talking about the mediator space and the mediator stance. I'm going to be spending a little bit of time talking about the space within which we mediate and the stance or the inner posture that the mediator brings with them. So the mediation space, first of all, although mediation is presented as an alternative to law and litigation, Beale and Rycroft point out that it also operates within what they call the shadow of the law. They describe some of the implications which I believe come to the fore, particularly in the type of mediation at hand within the RAF pilot project, and which are inter alia, that the parties operate within a perception of how the legal system would resolve the matter, and with the sense of time, costs, and implications of a litigated outcome. The extent to which mediation operates within the shadow exists on a continuum, with, for example, a neighborhood dispute existing lower down on the spectrum, and a medical negligence claim or a personal injury claim, such as the RAF matters, existing higher up on the spectrum and playing out strongly within the shadow of the law. It's for this reason, actually, that as the leader of ADR Network SA, I have sought out the support of organizations like the PRAC Guide, as well as SAMLA, to provide the architecture within which our mediators who venture into this narrowly specialized area of mediation can be rooted, supported, and ultimately grow in both knowledge and skill, whilst committing to align to both existing and emerging standards of best practice. Advocates Posman and Dutton will be specifically addressing how that may look and what mediators should expect and what should be expected of mediators in this area of mediation. Advocate Dutton goes on to speak more specifically to representatives, experts, and other role players within the process, while Advocate Postman will be looking at the actual process, as I understand it. So we mustn't forget, though, and lose sight of mediation as both an alternative to the legal system or to litigation, but also as a challenge to the legal system, and in particular its adversarial aspects, which can and do damage lives in very many ways. So this challenge to the legal system is in keeping with many aspects of our law reform projects, which are demonstrating and articulating a growing commitment to restorative justice and to alternative dispute resolution methods such as mediation as better fora for access to justice. It is also deeply connected to and finds resonance with the international integrative law movement and growing into initiatives in therapeutic jurisprudence or problem solving and holistic approaches to resolution of legal disputes. I'll make this document available to Ashley, who can send it out, and I'll send some links to good sources for you to have a look at those aspects. An interdiscipline stance is emerging and gaining momentum with individuals within those disciplines starting to find resonance with their roots in healing. So the physician or medical practitioner as healer of the body and mind, the lawyer as healer of society and relations within it, the mediator as healer of the discourse, the builder of bridges, or the mender of the breach across impossible divides. And there's a growing realization that the disciplines need to work together in an integrated manner. I always say to those that we teach and mentor that it is difficult, if not impossible, to solve a dispute in a vacuum. So we mediate in matters like this. We must hold both in mind. We operate both within the shadow of the law, and we operate as a challenge to particularly the adversarialism of the legal system. So let's look at operating within the shadow of the law. I'm just going to concentrate on some of the sort of grounding aspects. At the outset, it's important that we know and understand that at common law, all mediation is protected under the without prejudice doctrine. It is as far as mediation amounts to attempts to settle a legal dispute, discussions are off the record and without prejudice to both and or all parties' rights. This means that deeply embedded in our law is the recognition of and protection of the sanctity of attempts to settle legal disputes apart from the pursuit of litigation. This means that we can think of the law as regarding non-adversarial attempts to resolve disputes as sacred, and so should we. The without prejudice doctrine applies automatically even without uttering a word. Obviously that word is uttered, and it's probably in all the foundational documents that Michelle will take you through, but it is prudent for the mediator to articulate it in the process as well. We're not dealing with facts, but also with perceptions. And if parties perceive that it is not a safe place, discussions may be guarded and defensive and may not progress to the robust and open discussion that may be required for real resolution. So we may literally say, you're safe here. This process is off the record, without prejudice. It's confidential. It's important to get our parties bought in and committed to that, and to imbue in them a sense of trust that may also underpin the courage they may need to proceed through tough conversations. Naturally, we need to be wise about tough and robust conversations at the table. And if we need to use reality checking techniques or confront parties about bad behavior or lack of good faith, which we sometimes do, then we must circumspectly consider doing this in the caucus meeting. We must never forget the significance of face saving at the table and designing our processes in ways that neither party has to lose face, and that tough conversations can be held with dignity, respect, and reverence, holding in our minds at all times the sacred human within. Even though the process may firmly operate within the shadow of the law, what we don't want is for the process to feel like court. We have just taken a traumatized victim out of the midst of the adversarial system. We don't want the process to be different in name only. We want the process to actually make a difference, not only to the victim, but to all of society, bearing in mind that as the single biggest litigator, we may have no or little concept of how much collective resources drains away to RAF litigation. Some years back, we trained a number of Tanzanian High Court judges. They had court annexed mediation for several decades. South Africa was still in the throes of setting up our first pilot project in court annexed mediation. I was curious as to why they had sought out our mediation training. And they explained to me that they recognized that whilst they had the system and the rules, parties resisted it because they said it was not enough of a departure from court. In their system, judges were expected to mediate in chambers. They felt that the parties perceived that this was the same process, just in another room. We must work carefully to avoid this perspective. Naturally, there's much more to say about the mediation space and the extent to which it may operate within the shadow of the law, and the continual work it takes to keep parties vested in the process and operating off a base of good faith and candor or openness. Time doesn't permit us to mine the depths of this conversation, but merely to point to this conversation, which must, of course, be ongoing. So let's turn to the posture, the inner posture the mediator brings to the table. Indelibly and intricately bound up with the mediation space is the mediator's stance. This is our inner posture, and we must know that we bring that posture to the table. In his book, Peace at Work, John Ford talks about how students in martial arts training are taught the benefit of various body and mental postures. The totality of these postures, when adopted together, amounts to an effective stance for defense and attack. Not good language for mediators, but it's a good analogy. Students are taught to adopt this stance when presented with a challenge, notwithstanding any contrary reflexive or reactive instincts or habits. He goes on that the familiarity of the stance inspires confidence and prepares them to meet their reality with competence and agility. It ensures, he says, that they are on the best footing possible. He talks about the following aspects of such a stance as follows. We bring the real self as mediators. So we want to dismantle the egoic operating system. We want to be the real self, the authentic self, the humble self, the no agenda self, no personal agenda self. We bring a relaxed and calm stance. We're open to subtle information and feedback. We're aware. We are empathetic rapport builders. We are balanced and omnipartial. This means that we are equally there for everyone. We are collaborative process guides, not decision makers. We are the keeper of confidences, the respecter of differences, and we are inspiring beacons of hope. It was born out of a similar commitment that on our mediation training programs, our mediators are expected to undertake deep self-work, and they're also expected to undertake this work as a commitment to lifelong learning. It's not expected that we all miraculously overcome our deep woundedness and brokenness in each of our own lives, but rather that we acknowledge that we are all made up of everything that has happened to us and everything that we have learned and experienced along the way. And that for this reason, we consciously adopt, develop, and work at an inner stance or posture that we bring to the table, alive to the fact that high conflict may be contradictory, chaotic, confusing, and the mediator must adopt a posture that is able to consistently, thoughtfully, and wisely bring dueling parties back to a grounded median in order to best explore and work towards the possibility of resolution. We work with and encourage our mediators to lifelong self-reflection, lifelong seeking of wisdom, a lifelong commitment to awakening, to being more aware, and to develop an intuitive operating system that can work in and around our hard skills. That's what we know, our intellect and our learned skills. Dr. Cornel West talks about what it means to be human. He talks about the courage required for humans to learn how to think for themselves, to learn how to love and to laugh and to hope. Differently put, and in the Socratic tradition, the unexamined life is not worth living. the Greek actually says that the unexamined life is not the life of a human. It is to be acknowledged, though, that we must be ever present to the fact that the stance alone, our inner posture, no matter how strong, how peaceful, or how grounded, or how real, is not enough for a mediator working within the narrowly specialized field of medico-legal work. And as such, and as mentioned, it is the intention that our mediators and those that relate to other organizations can become grounded and grow and develop within the architecture of the ongoing content and knowledge provided by organizations like the PRAC Guide in medical law and ethics on the one hand, and the standards, protocols, and best practice set up being developed and researched through SUMLA, with research initiatives like that of Posman, contributing to what may emerge as a lighthouse of best practice in this area of mediation. In conclusion, I'm very excited to locate our mediators alongside the mediators of other organizations within a matrix, an architecture, if you will, that provides access to ongoing, up-to-date content in the area of medico-legal mediation that helps our mediators to align with and grow and develop firmly within an environment sincerely considering issues of best standards and best practice in this area of work, and to grow and be enriched by the various disciplines that SUMLA has and is drawing together to continue to grow, reflect on, and develop this work. Thank you very much for having me.
Well, thank you very much, Sheena. I didn't mention to anybody while introducing Sheena, because it shone through everything that she said, that Sheena is a shining example of transformation and restorative justice. So Sheena, you are a real benefit to us, and I thank you for your heart and your wisdom and your learning. And I encourage everybody to
Thank you.
learn from Sheena what she can teach. And essentially, in terms of the very narrow issue of RAF mediation, Sheena told us how to earn the trust of the participants. We cannot pretend that they should trust us or demand that they should trust us. We must be a person who they want to trust. And the way we behave in the mediation must be a reflection of what we are, and that is what they must trust. So Sheena, thank you very much for helping us to see that way.
Thank you very much.
Then I would like to invite Advocate Michelle Posman. Just a very brief introduction. I only got to know Michelle very recently, and I'm sorry I didn't get to know her a long time ago. But Michelle is an advocate, but for many years has been functioning as a mediator. Michelle has been deeply involved in many attempts and processes to involve and promote mediation in South Africa in different fora and methods for very many years. And she has got the experience of bureaucracy and the experience of personal interests and everything that stands in the way of mediation. But nonetheless, she has carried on as a firm and a believing advocate of mediation and a mediator. Michelle, we are really very grateful and honored to have you participating in this project, and we are pleased that you have already started participating, and we would really like to hear what you're going to tell us in terms of orientating us and giving us tips and advice in relation to the RAF pilot project. Michelle?
Thank you, Herman. What a wonderful introduction. Welcome to everybody on this call, and thank you for being with us this morning. Just get my PowerPoint going. So I chose this graphic as representative of the significant collective effort going on behind the scenes to make this project work. And I have to start with a vote of thanks to Dr. Herman Edeling and Judge Niels Claassen from SUMLA, and Justice Mbluli and Chanel Dick from the Road Accident Fund for making this happen. It's a shining example of what collaboration, tenacity, and goodwill can achieve. As Herman mentioned, I'll be giving you an overview of the project, and then Ian will take you deeper into the specifics of handling and analyzing RAF claims. Please feel free to record questions in the chat. We're not going to take questions now, but there's sufficient time right at the end to get to all and every question and comment. So I'm going to dive straight into mine and try and orientate you in the pilot project. Buckminster's law derives from the futurist and inventor Buckminster Fuller, who dedicated his life to making the world work. This principle that's up on your screen is exactly what Sumler and Raff are doing, and I want to reiterate my commendation to both parties for the significant strides they have made in shifting a deeply entrenched paradigm. No easy feat. The project came about by the signature of a memorandum of understanding between the two parties, which included agreement on the terms of a standard agreement to mediate to be used for every mediation in the project. It's important to note that the project has two components to it. The one is a training component and the other one is a research component. So the model of two observers with the two mediators, the mediator and the co-mediator, is a very sound model for training and mentorship. And the idea is that the observers observe at least 2 mediations before they may go on to co-mediate. And even after 2, if they're not comfortable enough, can observe a few more before they're ready to take up the reins of co-mediator or mediator. So a very good sustainable model for the development of mediators in these matters. So the other component, as I said, the one was a training component, the other is a research component. A lot of data is collected from each mediation using the information gained from the various forms used. And this information or data is going to be used to evolve the model and determine the best practice going forward. So there's going to be a progressive attempt throughout the project to examine the data being collected and see if we can do things better and how we can improve. So far, 6 mediations have been conducted, and it's become quite evident that there are 3 levels of competence required to effectively engage in these processes. The first one is conducting yourself in the mediation in whatever capacity, and Sheena's given us a good insight into what that involves. And what struck me during her address was the importance of our mediation journeys being journeys of self-discovery. I think we forget that a lot of the time. So the first one is conducting yourself in the mediation. The second level of competence is the technical and practical skills required to mediate these matters online. Mediation itself requires great skill in holding the space for the parties. And when you're doing it online, there's a whole nother level of competence and skill required. And then the content knowledge of handling the RAF claims. So I'm going to focus on the second tier of competence, and then Ian will focus on the last one. So on to an overview of mediating these matters: preparation, preparation, preparation. When you become involved in the pilot project mediations, you'll receive a link to 2 sets of documents. The first will be a link to the standard documents used by Sumler. There will be an agreement to mediate, the minutes of a pre-mediation meeting, the observer reports and some settlement agreement templates, as well as the Sumler guidelines and protocol. And I would really encourage anyone that's going to participate in this project to become familiar with those documents. It will go a long way to enable you to contribute and participate meaningfully in these mediations. So that would be the one link, is the standard documents. The other link will be the confidential documents pertaining to that particular mediation. So that will be the pleadings, the expert reports, and any joint minutes. And again, familiarize yourself with those documents to get the most out of the mediation process, even if you are observing, in fact, especially if you're observing. so important to go through those 2 links and all the documents in order to prepare. Also know what your role is going to be in the mediation process and which documents you will be responsible for in the process, because it's important, because so the documents require a lot of information and are time consuming. So the more you can pre-populate those documents before you go into the mediation, the quicker and easier the process will be. Another aspect to consider in the preparation is the issue of language and the need for a translator. You don't want to get caught short at the mediation, suddenly realizing that the plaintiff may need an interpreter. This is what the guidelines and protocol for mediation look like. So as I said, it will be sent to you along with the standard documents and also appears on SUMLA's website. So anyone wanting to become involved, this should be your first go-to document to orientate yourself and become familiar with the way these matters are run. So once you've done your preparation, the next step would be entering the room or all appearing on the screen. Present at these mediations will always be, as Herman said, a mediator and a co-mediator, preferably one legal, one medical, and then the 2 observers. Also present will be the RAF project coordinator, Chanel Dick. There may be RAF observers present, and then of course the RAF representative and plaintiff's attorney, and perhaps the plaintiff as well. The mediator will take you through the Zoom functionality, and I would recommend to anyone, again, wanting to become involved in this project, to become relatively comfortable and competent with Zoom. And I'm going to do a little marketing thing here for Aslan. They're running fantastic Zoom training, which is an hour and a half and relatively inexpensive and really worth doing. Because, as I said, you know, holding the space in the mediation is one thing, but when you have to worry about all the technical issues on top of that, the more comfortable you are, the easier it is. The mediator will also then explain that this is a pilot project being run to develop the practice of medical mediation, and remind the parties that the process is governed by the MOU between the parties, and that the documents being used are all standard documents. And that are standard documents, and that a lot of the info required is for research purposes. The last issue that needs to be considered is the issue of connectivity. Connectivity can really be a problem, so always important to put contact numbers in the chat in case somebody drops off and you've got a means to contact them and bring them back into the mediation. The first thing that will happen in the room once everyone's orientated is the pre-mediation meeting will start, and this is very particular to the SUMLA model, where every mediation is preceded by a pre-mediation meeting with a view to obtaining informed consent to mediate from the parties. The pre-mediation minutes form a big part of that pre-mediation meeting, and one of the observers will be responsible for populating this document and filling it in, making sure of a number of issues. The one is that the parties have settlement authority, that the RAF representative has settlement authority and the plaintiff's representative does. Check that all the parties understand what mediation is. Confirm that the mediation process being used by SUMLA and RAF is facilitative, so that the mediator is not going to advise any of their parties or make any decisions. And then go through the principles of mediation. So the fact that it's voluntary, it's confidential, without prejudice, non-binding until signature, and flexible. Once the mediator's gone through all of that information in the pre-mediation minutes, he or she will record what is still in dispute, and important, confirm that there are no fees payable for the mediator because this is a pro bono pilot project. The parties then consent to the selection of the mediators and confirm that the observers are bound by the same confidentiality as the mediators, and get the parties to consent to the observers being part of the mediation as well. So a lot of important issues addressed in that pre-mediation meeting, and it should end or conclude with the agreement to mediate. As I said before, this agreement is a standard document. It's an annexure to the Memorandum of Understanding with RAF, so the terms have all already been agreed. The mediator will run through the document quickly and confirm the appointment. Confirm that both parties are happy to sign. Now, because this is an online mediation, a signature is not possible at the time, and the method being used is to switch the record button on, confirm the agreement to mediate, and then confirm everybody's agreement on record. Once that's been done, the agreement to mediate is then circulated to the parties in due course for signature, just so that we've got it for everybody's records. So that concludes the first step, the pre-mediation meeting, concluding in the agreement to mediate, and then the mediation can commence. I'm not going to spend too much time on the actual mediation. That's what the agreement to mediate looks like. Just to say again, running the mediation, the parties need to be very comfortable with the Zoom scenario. The mediation will take place in joint session and in breakout rooms, and the mediator will move between the two. Mediation ends in settlement, and again, the parties need to confirm that they have the settlement authority, and hopefully an agreement of a settlement agreement can be drafted and signed. The SAMLA have provided many settlement templates, so one of those will be used, and again, settlement is recorded on camera and physical signatures are obtained afterwards. After all the formalities, the observer must ensure that they have all the information necessary for the observer's report. There are questions in there like, so it's all the technical information, but there are also questions in there about the satisfaction of the parties in the process, if there's anything the parties feel could be improved. Is an assessment of the mediator, the conduct of the mediator, and of the co-mediator, and also, yeah, so it's quite a comprehensive document, and this document particularly forms one of the cornerstones of the research component of this project. Once the observer's report is completed, there will be a debrief. So the plaintiffs' representatives and RAF representatives will be excused, and a debrief will happen between the mediator, co-mediator, and the observers, just to discuss key learning points, key turning points, and the conduct of the parties. Quite a useful mechanism for learning. So that's more or less an orientation of how these work. We're all learning exponentially through this project. And it's a good idea to consider your skill set, your particular skill set, in terms of these 3 levels of competence, where your gaps are and where you need to upskill. I encourage you to join us on this journey and contribute to the evolution of RAF claims. Thank you for listening, and I look forward to engaging with you more if there's questions and discussion afterwards. Thank you, Herman.
Thank you very much, Michelle. That was marvelous. I want to just mention to everybody who's going to enter this project that what Michelle said gave a very useful and practical overview to what you're going to do and how things will happen. If you forget any of it by the time you get to the mediation, don't worry, because you'll come in as an observer, and both the mediator and co-mediator will have had exposure to this research process and training process in a few mediations, so they will see that everything is done the right way. And the mediator and co-mediator will also remind you of your particular duties and responsibilities in the mediation. So you don't have to write anything down. It's good to understand what Michelle has taught you, but she has pointed to documents. You will gain access every time you are registered as an observer or a mediator or co-mediator. You will get access to the standard document folder, and you will get access to the confidential folder in which the documents of that particular matter are stored and in which you have undertaken a duty of confidentiality. So, Michelle, thank you very much for that, and thank you for your great contribution to the success of this project.
You're welcome, Herman. Thank you for involving me.
Thank you. Just before introducing and inviting Ian Dutton, I wish to bring an important point to your attention, and I'm going to want to share my screen for that. So it is this.
Oh, did I stop?
I'm showing you here from this document, Guidelines and Protocol for Mediation of RAF Personal Injury Disputes. And this one is identified as version 5, which was settled in May 2020. The authority of this document is that this is an annexure to the MOU between SOMLA and the RAF. So the terms of this document are agreed to by SOMLA and the RAF that this will be used in the mediations. Now, in this document, I'm sure that as trained and accredited mediators, you are all very well aware of these different styles of mediation. They are described very briefly in this document: transformative mediation, facilitative mediation, evaluative mediation, and adjudicative mediation. Now, each one of these styles has a particular role in particular circumstances. And I'm not going to talk now at all about which one is better in what circumstances. What I'm going to emphasize is that it is possible, and often it is necessary, for a mediator to start in one style and then move for a time into another style and then back to that style, or to progress. So it is necessary to shift between styles. And I think it's very important to be aware of what each style means and which style you are going to mediate in. It is also important that you must get consent from the parties to use the style that is appropriate. Because in a mediation, as much as the mediator controls the process, all decisions, the only decision-making authority is agreement between the two parties. Now, it is already agreed between SOMLA and the RAF, and this is where I want to show you the other document. So this is the standard agreement to mediate that Michelle has referred you to. This document also forms an annexure to the MOU between SOMLA and the RAF. So the terms of this document are also specified for use in these mediations. Are you seeing? No, I have to stop the share there, I suppose, and then start share again and get the agreement to mediate. Okay, so clause 8 of this standard agreement to mediate is that the mediation will be conducted in the styles of facilitative mediation and or transformative mediation. And there it refers to the SOMLA Guidelines Section 2 to say what those are. So for purposes of this project, irrespective of your personal view of the potential benefit of an evaluative mediation or the potential benefit of an adjudicative mediation, the parties are bound to those two styles. Now, most of what we do is in the style of facilitative mediation. The style of transformative mediation is only really relevant to calming down the emotions or the storms or the distrust or the anger that might rage at the beginning, to bring the parties to see one another as human beings and to actually want to talk to one another and solve the problem. As soon as one is at that point, and one may start off in that happy place, then the mediation has to remain in the style of facilitative mediation. Now, in addition to the fact that this is specified by the RAF in terms of our pilot project and agreed by SAMLA, there are two other important points as to why we must practice facilitative mediation. The first is, and I think Ian Dutton may talk about this, even though the word is not used, the wording of the Rule 41A rule is facilitative mediation. That's what it describes and what it refers to. So when we get outside this pilot project into Rule 41A mediations, which are probably going to occur more and more, we should know and be proficient in facilitative mediation. The other problem, or the other reason, is maybe more in terms of protecting the mediator, because we don't think that negligence or malpractice claims against mediators are a very big thing. But we all know what a big thing clinical negligence claims against doctors are. And 20 years ago, doctors didn't worry about that. They didn't really think that people would claim money from them. Now, we have to think about protecting ourselves against negligent or malpractice, professional malpractice claims. The most likely basis for such a claim would be if a party were to allege that you as mediator presided over a process where there was a major undersettlement of the claim without bringing that to the attention of the party, and therefore facilitated an undersettlement. And then it may be that that party tries to claim the amount of that undersettlement from you. In terms of that, our experience has been that at times, particulars of claim in preparation for litigation are drawn up by relatively inexperienced plaintiff attorneys, and that sometimes really unrealistic numbers are recorded in those particulars of claim. We then come to a mediation and everybody agrees openly that this is now the right number. But if the number started off at 5 million and everybody now agrees that the right number is 750,000, then on the face of it, the mediator has presided over a process where a claim of 5 million was settled for 750,000. That opens you to being accused not by that same attorney who was in the mediation, but by another attorney who picks up this source of income to say, well, I want the other 4.25 million rand from you because it's your fault. And the reason that I'm claiming it from you is you bullied my client and his inexperienced previous attorney into settling this. You persuaded them to accept something which you knew was not right. Now, in the style of facilitative mediation, there is no persuasion. There cannot be any bullying because the mediator does not propose any solution, does not make any recommendations for what it should be. The mediator only facilitates, the parties come up with their suggestions, etc. So in other words, in order to be even notionally guilty of persuading a party against his or her best interests, you would have to have moved into the style of evaluative mediation. So that is why, for our own protection, it's important to stay in facilitative mediation. And in the standard agreement, it states that if any party or representative perceives or believes that a mediator has ventured outside these styles or has any other reason for discomfort or concern, this will immediately be brought to the attention of the mediators so that the perception, belief, or concern may be addressed prior to signing any settlement agreement. In other words, if the parties have agreed to this agreement and then they've agreed to a settlement agreement, they are then bound by these terms. And they cannot then come and say a year later that somebody else says, you bullied my client, or you persuaded my client, or you brainwashed or pulled the wool over my client's eyes, because the client and the attorney agreed that if they had any such perception, they would raise it before signing the settlement agreement. Thank you very much. So just to focus your attention on those important issues, it is now my very great pleasure to introduce Ian Dutton, who I think is more of a friend than anything else, but Ian and I met each other, I think in 2015, Ian, at about the time that you were writing your book. Your book was almost done, and Ian became he started a branch of SAMLA in KZN, and he was the first chairperson of the SAMLA branch. In that capacity, Ian and I have developed a very interesting and to me very beneficial professional relationship. Ian also was very engaged in SAMLA's efforts to create a medical coalition in South Africa, and although we made very good strides in that regard, the strides were mainly in terms of promoting trust and relationships between organizations rather than so far getting to any practical on-the-ground effects. However, we still believe that there is a future for the formal development of this South African medico-legal coalition. And more recently, I've had a lot of communication with Ian about his PRAC guide activities, and flowing out of Ian's book, Ian has a website, and he does interviews and webinars in relation to medical law and the practice and ethics of medical law. This is in many certain ways different than the SAMLA postgraduate training, but it's a very good adjunct. So the SAMLA training process can do certain things. Ian's process, which is like a sister process or a brother, I'm not sure, Ian, is
take your pick.
Very, very welcome to us, because I believe practitioners can benefit very much from what Ian does, as well as benefiting from what we do. So we have a very happy collaboration between SAMLA and PRAC Guide. And now Ian has been right from the very beginning, when we first started to write the SAMLA guidelines and protocol for medical mediation. Ian was part of that foundational process, and he's been a staunch ally ever since, and has currently participated in this RAF project. And Ian, together with Michelle and Sheena, are now engaged in establishing a KZN mediation pilot project with the Department of Health, similar to the SAMLA's current projects with the Mpumalanga and Gauteng province. So it only strikes me right now, and I'm really glad to notice this, that we have 3 people, all from the Kingdom of KwaZulu-Natal, talking today. It just shows you that us in Gauteng are willing to learn from anybody. So with that, Ian, over to you.
Thanks, Herman. I'm going to avoid the temptation to have a riposte to your remark. I think I'll let Sheena and Michelle's presentation speak for themselves, and I'll try and support them in mine. But Herman, I think just to pick up, to start with, just to pick up on 1 or 2 points that Sheena and Michelle and yourself now have made. This process of mediation has at its heart, and particularly within what I would say more broadly, medical mediations, which include clinical negligence type mediations, so whether against the MEC or in the private healthcare sector, or other personal injuries where some sort of medical aspect is involved, or indeed RAF mediations in particular, which is what we're talking about today. But specifically within that field, one of the key features, and you really feel it as soon as you engage with this process, is how it really is a process of bringing different professional streams together. And that thread is like a golden thread running through medical mediations, and is a central feature of RAF mediations in particular. And that in itself leads us, and I must say, every single time I engage with it, including in this meeting, it's amazing how enriching the experience is. Because not only are you dealing with interesting subject matter within your own field, you're dealing with interesting subject matter from related fields. And what I'm always struck by is how interesting and sort of on the level of people sharing, how open people are that you engage with in sharing from their professional fields. So I make that comment as a general observation, but I also make it for a sort of practical reason. And I am going to deal in my presentation with what you might call the harder skills, or Sheena made an interesting comment talking about a continuum along which mediations happen within the shadow of the law. And RAF mediations, I think, happen very close to the law. So the hard skills are actually quite relevant. How you approach a matter, how you analyze it, what the legal principles are, etc., play a very influential role in the outcome of that matter. And I'll develop that during the course of this presentation. But the point I'd like to make at the moment is that during that mediation process, in order to have an effective RAF mediation, you have to be open to and be able to assimilate the experiences of your fellow professionals from different professions. So for instance, if I as a legal practitioner engage in a mediation, what is central to that process is being open to and being able to relate to and build relationships with people who have a rich mediation background. Sheena and Michelle have that. Sheena in particular is a mediator, and then people from the healthcare professions like Herman. And if you can do that, and if you can build that rapport and you can start mining the information which is at your disposal as a mediator, then you really are starting to build a team around which this mediation happens. And then what you do is you start drawing in the representatives from both sides. So you have your plaintiff's representative, and I know as counsel that when, no, it doesn't matter what sort of matter I do, but obviously particularly medical matters, my instructing attorney is a tremendous source of information with their own skills, with their own experience, and my approach has always been, if you can build a team around a matter, it's so much more effective. And I'm finding exactly the same thing with mediation. I had a consultation yesterday where our client made a phenomenal input on a very difficult technical matter. And our client, it is a medical negligence case, and our client had gone around to his family members who actually happened to be in the medical field and came up with some really fantastic points. So everybody, including the clients, have an important role to play and must not be overlooked. And what I would say, particularly with I'm looking on the harder skills end of the spectrum in this presentation, but Sheena made an important point. I think sometimes as lawyers, we go into legal matters and we're really just looking at those hard skills and looking at the bottom line and the numbers and how do we get to a settlement. But we seem to forget that even in RAF cases, there is a victim and there is a person who's been injured and who has a physical injury. And I am learning along this process that to remember that and to bring that into the mediation and to acknowledge that. So those are just some sort of preparatory comments that I'd make. Now, against the background of those comments, I'm going to turn to a little bit more of those harder skills. But because of the nature of mediation, in this presentation today, your presenters come from a range of different backgrounds, and I know that the viewers come from a range of different backgrounds. So immediately we encounter this phenomenon of me as a legal representative, and Lee is here, Michelle knows this. We all have, years now of experience, decades of experience in dealing with the legal matters. We have people who are engaging in this session now who have no background in that. And then, of course, the converse is true. The legal representatives have very little background in mediation. And, of course, healthcare practitioners come from their own background. So when you present along the lines that I'm going to, you have to try and bear in mind that there are different backgrounds and there are different levels of knowledge. So some of what I'll go over, especially to the legal practitioners, may be fairly standard fare. I have my own particular approach to it, and I always find watching another professional and how they do it, another legal practitioner, how they do it, I learn a lot from anyway. But I think that as legal practitioners, we have our own particular approach. We built it up through negotiating and running litigation around RAF matters over many years, and it works for us. When you go into mediations, what I would urge the legal practitioners to do is to develop the skill of stepping back from your established skills in litigation, and really having a think about those foundational structures of how you prepare your cases, and be open to what healthcare practitioners can contribute and what mediators can contribute in building your model of how you're going to deal with mediation, because it is a completely new emerging profession. So there will be comments as I go through my presentation along those lines. And then to healthcare practitioners and mediators who may not have engaged in any RAF matters, there are a couple of preliminary points I'd make. Firstly, look, the content is demanding, and you can't get away from that. Michelle, I thought, just hit the nail on the head when she said preparation, preparation, preparation. Michelle, you'll remember Chris Marnovic teaching us in pupillage and drumming that into us, and it is so true. And the more I practice, the more I realize that your preparation sets you up for success. And the harder you work, the luckier you get. The harder you work, the more successful you are. The harder you work, the more skilled you are. So I'm afraid that I can't give you sort of any comfort in that regard and say there's an easy route to this and that there's a quick fix. Even what I'll discuss today is we'll really just be able to deal with an entry sort of topic. But the bottom line is that if you apply yourself and you work hard and you're disciplined, then those skills will come to you, and you will also emerge from the pack. I truly believe this, and that the work will find you. And Herman actually taught me this once. He said that every single matter he does, he makes sure that matter is done to a level of excellence, and he applies himself fully to that. And it's not just a sausage factory. And that way the work finds him, and I endorse that in my practice, and it really is something to think about. So that's the first point. But now, having said that, I don't think it's enough to just leave people with that thought. Those that litigate will know that the way into an RAF matter is to have a system, a procedure, and through that system and that procedure to have skills and techniques that will allow you to master a volume of material and to get to what really matters in that case. And that way you get on top of the information, you're familiar with it, you're confident with it, and you can then apply that information in whatever way. So if you're a legal representative, you can represent your client's interests in the mediation by negotiating and knowing what you're talking about, knowing the facts, knowing the issues. If you're a mediator, you adapt that knowledge and you apply it in a similar way. Same with the observers. I'd go to some effort, try to find out what the issues are, and practice effectively your skills through that process. I am going to just pick up on one point that Herman has already touched on, and I think I must therefore just spend a minute or two on that, and it'll be helpful. Herman, is that 41A on screen?
Yes, it is, Ian.
Okay, thank you very much. All right, so I'm just going to take you to Rule 41A, mediation as a dispute resolution mechanism, and I'm just going to elaborate briefly. I don't want to spend too much time on this as a topic on its own. Herman has set it out very accurately and well. But I just want to develop the one point that he made. So 41A sub 1 is a definition subsection, and you'll see there are two definitions. There's dispute and there's mediation. I'm going to focus on the second of those definitions, mediation. Let's read it through together, and then we'll take it from there. My wife just taking my car keys. I don't know where she's going. All right. So mediation means a voluntary process entered into by agreement between the parties to a dispute, in which an impartial and independent person, the mediator, assists the parties to either resolve the dispute between them or identify issues upon which agreement can be reached, or explore areas of compromise, or generate options to resolve the dispute, or clarify priorities. And Herman, the word actually is facilitation isn't there, but facilitating is there. By facilitating discussions between the parties and assisting them in their negotiations to resolve the dispute. Now that underscores what Herman said. So you can see that, and Sheena talked about the stance of the mediator. And there we go. The rule is telling us as mediators, this is how you approach the matter. And they actually set out in some detail and what's expected of you and what's expected of your stance and how you're supposed to go about assisting the parties in exploring whether they can reach settlement. there is a dividing line that starts playing out very quickly in practice. And I want to make this point within the context of these mediations. So you'll see that I think that probably the key word in that paragraph is facilitating. And your role, and that sums up the role of the mediator. But now, what often happens is in the process of facilitating these discussions, they're effectively settlement negotiations for the lawyers, but they're supervised. And it's like a turbocharged settlement negotiation in that it's given proper structure. There's a tremendous amount of thought and experience that goes into the way that a mediation is set up and structured. And it's in my view, an extremely effective process for that reason. But by facilitating discussions, what sometimes happens is that you get an insight because of your professional expertise. And you may start forming a view as to what the appropriate solution might be. Now here, you have to tread carefully, but there's a paradox here. You have to tread carefully, but you have to also be bold in the appropriate way. And if you start seeing that there's a way that the parties might find a way through the forest, but they're not finding it, then what you need to do is to focus on the facts, focus on the lines of argument that lead those parties to those conclusions. And my preference is not to dictate. Herman's dealt with that. To generally try to avoid a sort of evaluative style, and to rather use a Socratic approach. In other words, get the parties to think about their own cases. Think about why it is that they're adopting that position. What is the logic? What's the argument? What are the facts that underpin that conclusion? So how do they get to hold that position? And if you feel that, well, maybe that position shouldn't really be held by them, should we explore whether that's correct? The way, in my view, to approach it is to get them to start thinking about their own position. Now, in order to do that, you actually need to know the facts and the arguments very well yourself. And so it goes back to that point of preparing and hard work. If you understand the positions of the parties and how they got there, and you understand how the parties in particular get to hold certain positions about rands and cents through various experts and what they actually eventually calculates, and you can see that there may be an issue there. Obviously, you're alive to the fact that you might have it wrong. But to explore that process with them, to me, that lies at the heart of facilitative mediation, and particularly in RAF matters. And related to that now is the way that you use your medical practitioners. Your medical practitioners have a tremendous insight and skill and ability to very quickly get on top of the medical, or a lot quicker than the lawyers can, because that's their field of expertise. And we must be humble enough to accept it. And the lawyers and the medical practitioners can be a tremendous source of assistance in this pilot project. If you co-mediating with a doctor, you take a senior practitioner, they can a lot more easily than you can get on top of those complicated medical facts. And that takes a lot of pressure off you as an individual if you're a legal representative or if you're a mediator, because you're guided by that healthcare medical practitioner. When I say medical practitioner, I mean healthcare practitioner. Allied professions are extremely important in this process as well. So that goes back to the earlier point that I made about teamwork. So let's just have a look at the next point. So what I do want to, let me just recap that before I go back to the document. So basically, what Rule 41A sets up is a dynamic in terms of which our approach is understand the facts, understand the arguments well, and then from that point onwards, work to build a team, work to build trust, establish trust amongst the parties, and then from that point, you can move forward in your mediation. So I just want to show you here. Basically, this is a matter that I'm actually working on at the moment, an RAF matter. And I just want to for those that maybe haven't ever encountered this, I want to show you the sorts of documentation. Now, this is in hard copy form. Michelle has covered that what will happen in mediations is that you'll get this sort of document in electronic format, and that's absolutely fine. But you'll see that what will happen is that in RAF matters in particular, and this applies to clinical negligence matters as well, but I'm not going to, for the remainder of this presentation, I'm not going to deal with any other type of medical mediation. I'm going to focus on RAF. So in RAF matters, you will get volumes of information, and you can see from this page. I mean, look at this. We're on page 524, and I will. In fact, I've got the brief here. You'll see that this, just for those that haven't been involved in this, I'll try not to show the attorney's name, but that's volume 1 of the documents, and as if that's not enough weekend reading, there's volume 2. Okay, so that now is the brief that you have to master. So when we talk about mastering facts, there's a lot to assimilate. And now I'll go back to my earlier point. How are you going to help to guide and facilitate the parties in the process if you don't know the highways and byways through all that volume of information? So you need a process, you need a structure. And I'll make this point that it is an error to simply start reading at page 1 and think that you're going to get to page 750 and you're going to be in a position to mediate this matter or to represent a client. Because there's no way that you can retain all that information. And you'll find as you start reading all these reports and you start dealing with contradictory positions, that it becomes confusing, because one expert says one thing and another expert says a different thing. So that is not going to work. And what you actually need is a better structure and some sort of plan of action here as to how you're going to actually deal with this volume of information. Herman, is my spreadsheet up there?
No, yeah, not now.
You need to share screen, Ian. You're not sharing at all.
Sorry, just a sec. Just give me a second here to get this up. Right, just while I pull that up. So you need a plan and you need a way to get through that volume of information. Now, the way that I would suggest you do it, and let me just actually take you back to this while I've still got it, is that you start off with the way I do it, I know some people do it slightly differently, and I'll touch on that in a moment, but you start off with this report, which is your industrial psychologist's report. And in conjunction with that report is your actuary's report. And let's just see if I've got the actuary's report here. So if you look at your industrial psychologist report and your actuary's report in conjunction, there's the actuary's report.
Ian, you're not sharing screen.
Beg your pardon. Sorry, just a sec. Just give me a moment. I've just lost those reports now. Okay, I'll come back to those in a second. Let me take you to a different way of approaching the same topic. Can you see the Excel spreadsheet now, Ashley?
Yes, we can.
Okay. All right. So let's just take you to this. You'll see that, and I'll take you guys back in a few minutes back to that example of industrial psychologist report and actuary's report. The industrial psychologist report, the way that I approach that is I read the industrial psychologist report together with the actuary's report. I tend to approach it on the basis that those are sort of two parts of the same information. Now, why I do that is because your industrial psychologist report will give you two things. It'll give you a sort of narrative of events. So it'll go through all the medical information, and it'll go through an assessment of what the actual facts of the matter are, and it'll give you information. So, for instance, what the type of employment is that the person did, what their future prospects are, and it actually brings everything together in a sort of summary form, and all the contents of those two lever arch files are brought together in a nice, convenient summary in the industrial psychologist's report. And I like that industrial psychologist report as a starting point, because what it does is it gives you the medical information and it gives you a bridge to the financial information. So it's a good entry point. And I would suggest that instead of starting at page 1 and working all the way through to page 700 or 500 or whatever it happens to be, go to the industrial psychologist reports first and read the industrial psychologist report. They're a handy summary, and they get you straight to the heart of the matter, which in RAF matters is really what's very important is the amounts always for each of your heads of damages. So if we have a look then at the way that I then assess industrial psychologist reports, and this is my particular method. You can work out your own method. The important thing is that you use some sort of mechanism to record what you're reading in the industrial psychologist reports, because what's going to happen is when you get into usually this court, or if you go into mediation, in particular in this case, the moment you get into that mediation, things happen very quickly. And you need to be able to get to facts and to cross-reference, and people make loose comments, and you need to know where to find information. So I find a summary like this and a spreadsheet like this is tremendously helpful. So if I look here at my loss of income, which is the first the first aspect that we'll look at, you'll see that there are two aspects to loss of income. The first is but for the accident, and the second is now that the accident has occurred. And what we're looking for in this particular area is we're looking for what is the position, or what would the position have been, what we say, but for the accident. In other words, had the accident never occurred, what is that individual's, what would that individual's development have been? What would the individual's physical circumstances have been? What would their employment track have been had the accident not occurred? And you'll see that here, for instance, is a remark made by the particular industrial psychologist that same career trajectory as post-accident. So that is just a remark made by this industrial psychologist. And I then, in italics, I put these questions. What does this mean? Is she referring to past loss of income or to future as well? This needs to be clarified. So I've got a question that I want to ask of the industrial psychologist. She said it wasn't very clear in her report as to what she meant. Importantly, make a reference to the page on that spreadsheet so that when you deal with the parties, you can very quickly and easily get to that particular page in the matter, and you can go there and find and double check exactly what was said. So that is, and when you go through the exercise of preparing, it sounds now as if that's obvious to do, but I just know from experience it's very tempting to simply just go and read the report. And then you don't know exactly, you remember things, but you can't actually find them when you're in the sort of heat of the moment. And then you lose a very important thought. So noting that page is very important. I just want to show you, here's the defendant's industrial psychologist's report. So plaintiff and defendant. On the defendant's industrial psychologist report, she deals with it in a different order, but you'll see that here, there's a comment made, smooth increases until Patterson C3. 493,000 at age 45, then inflationary increases until age 65 retirement. And what she's saying is that had the accident not happened, in other words, but for, one would have expected smooth salary increases until this particular level on the Patterson scale at age 45, and then inflationary increases until age 65, which would have been retirement. So what this industrial psychologist is talking about is what would we have expected if the accident hadn't happened in regard to this person's employment. And if you then consider that, that's the same sort of point as the previous point that the plaintiff's industrial psychologist made. And that's why I've just put those two in yellow, because you can now start getting potential differences between those two industrial psychologists' approaches. In other words, this industrial psychologist wasn't actually very clear at all in what she meant. She actually didn't commit herself. But this one committed herself. And I far prefer this when they commit themselves on this basis. So in a mediation now, what one of the aspects that I would start exploring is, well, what does this mean? What exactly was referred to? And how does this industrial psychologist relate this conclusion to what her opposite number does? And in essence, does this industrial psychologist, in other words, the plaintiff, you ask the plaintiff's representative this, does the plaintiff's representative accept those that scenario is correct. In other words, that his salary would have increased up to 493,000 Rand until 45, and then inflationary increases after that. And when you're dealing with negotiating RAF matters, and now by extension mediations, that's the type of territory that you're exploring. And you're looking for those differences. And then what you're wanting to do is so firstly, in this case, you'd have to try to determine, well, is there actually a difference? It's not clear from the one report. Or is there an issue between the two parties? Or is there consensus? And so in a mediation situation, I would, as a first port of call, I would try to clarify this point from the legal representative or from the industrial psychologist or from somehow, or maybe there would be a joint minute in terms of which the parties would then reach agreement on this. But that needs to be dealt with. And then once you've clarified what exactly is being referred to by this particular industrial psychologist, then of course you can compare it to that and see where the parties are. So part of the process of mediating a solution is of course guiding the parties towards a certain conclusion. And the point that I would make, and people will see this when they start mediating, when they start observing, is that this type of work is extremely demanding as far as the facts and the arguments are concerned. It's not easy work. And you have to have a system, you have to have an approach in terms of which you can understand where the parties are going and how they're getting to that particular outcome. And so it is at this sort of level that the parties will either find each other or won't. So if I have a look at the next point in the industrial psychologist's report, and I've made a note, I'm not going to go to the actual report because it's lengthy and cumbersome. I've picked these out of the reports. But you'll see that the industrial psychologist says she would have continued in the same employment, plaintiff's industrial psychologist. The defendant's industrial psychologist actually says that she could have competed successfully for work in the public and private sector. So the first thing that I just want to then underline is I've got a page reference to where this person makes that comment so that I can find it if necessary in the mediation. So if somebody says, well, I'm not sure what you mean, or you can actually take them to that point in the documentation. And then you've got these two comments. And if you apply your mind to it, you'll see that it's actually quite interesting. The plaintiff's industrial psychologist is saying that she would have continued in the same employment. And the defendant's industrial psychologist is saying that the plaintiff could have competed successfully for work in the public and private sector. And in fact, it's quite striking that the defendant's industrial psychologist is a bit more generous in this regard than the plaintiff's industrial psychologist. And that point is worth knowing in a mediated context, because here the defendant is offering more than the plaintiff, was assessing more than the plaintiff. And that is a point that then, during the course of the mediation, can be explored. And now, the mediators in particular, I'm sure, their antenna will be going, because here's something that you can use, if you're skillful about it, you can use in breakaway sessions to start moving the parties closer towards each other by drawing the attention of one of the parties to this fact. In particular, I would have thought the plaintiff's representative, and you can start pointing out the plaintiff's representative, well, look, they've actually been more generous than your own industrial psychologist on this point. In other words, there's some financial benefit there. So that then, and just to go through for those that haven't dealt very much with these RAF type matters, what will happen is that you will identify from the pleadings as a first port of call. You read the pleadings, and you'll see from the pleadings different heads of damages, which will be either loss of income or past medical expenses, future medical expenses, etc. You'll see all those heads of damages, and those heads of damages will always be assessed in terms of what would have happened but for the accident, and what is happening now or what do you expect now that the accident has occurred. And it's the difference between what the person, let's take income earning capacity, so loss of income. The difference between what that person would have earned had the accident not occurred and what the person is now expected to earn that the accident has occurred, it's that difference that is the value of the claim. So just to, and it's very important to appreciate that. Then always bear that in mind. What you're comparing is a real life situation, in the sense of this is what we're actually dealing with. So let me take this example. Now that the accident has occurred, you're actually dealing with a scenario where the accident has happened, and this particular plaintiff, in fact, has reduced working hours. That is actually the position. And you're taking that position and you're comparing it to, well, what would have happened had the accident not occurred? In other words, would she have had reduced working hours? In this case, in fact, the position is that there wouldn't have been reduced working hours but for the accident. So your claim then starts emerging, and it's piece by piece, it starts emerging. So had the accident not occurred, in other words, but for, there would not have been reduced working hours, and she would have continued in the same employment as what the plaintiff's industrial psychologist is saying. And you will then arrive at a figure, and I'll show you in a minute how that happens. But just for the moment, the point is, had the accident not occurred, would have continued in the same employment, carried on as before, and there will be a figure attached to that. Now that the accident has occurred, because of the injuries, there's reduced working hours. So that's how you start dealing with so those sort of finer distinctions between the parties, and that's where you'll start finding the ground for negotiating an outcome. I'm just going to go through one more aspect. You'll see from the plaintiff's industrial psychologist that her assessment was that now that the accident has occurred, the plaintiff was actually off work 6 to 8 weeks. And that's the only comment she made, is that she's off work for 6 to 8 weeks. If you look at the defendant's industrial psychologist report, the plaintiff was off work for 6 weeks, but no loss of income. And why is that? Because the plaintiff continued to earn a salary during that time. So yes, she was off for 6 weeks, but she actually earned a salary. And so there's a difference between the two. And once again, in a mediation, that can then be explored. And do the plaintiffs accept that there was salary earned during that 6 week period? Let me just see if I can go back to that. Stop my share there. Just give me a second. Let me just go to those actual reports. Is it up, Ashley?
We've got, yeah, it is.
Those are the images of the reports, yeah? Okay. So let's then have a look at these documents. Let me start taking you through here. And I'll show you now how this comes through. Okay. So this is a portion of the industrial psychologist's report. And you'll see it from the index, and you'll find the heading. That's easy to do. Once we get to this level of the report, you see here she starts talking about loss of earnings. And you'll see immediately we look at pre-accident functioning. And now that goes back to the point that I made earlier. Why is that? Because we're going to compare what would have happened if there hadn't been an accident with what actually happens. Now we just have to be a bit careful here. Now just this little word of warning here when you engage with these things. Very often, and it's something that always astonishes me, very often experts are not exactly clear on whether they're talking about but for, in other words, had the accident not happened, or whether they're talking about past on the one hand, or whether they're talking about now the accident has occurred and future losses. Those are four very different concepts. And I often see people getting confused because they don't quite follow the reasoning there. And I'm just going to spend a few minutes on that and alert you to this. And as you go through these reports, be aware of it, and you'll become stronger and stronger at identifying what people mean. There's other expressions are also used, like pre-morbid and post-morbid. So those expressions, you have to be careful that you understand exactly what the writer or the witness is getting at in order to understand what they're trying to say. So you have your pre-accident functioning. So what this expert is saying, if you look at the content there, she is talking about the situation before the accident happened. So that's fairly straightforward. And you'll see here that she starts talking about work history. So this is previously what that person's whole work history is. And then we get to work potential. The occupational therapist, the name is out, of the view that the claimant has the functional capacity to work in a sedentary position from the age of 40 years. She will have difficulty working a full day beyond the age of 50 to 55 years. Okay, so actually what she's talking about there is, had the accident not occurred, but for. So that's that hypothetical scenario. So when you make your notes, you must just be alive to this, because what she's actually talking about is, had the accident not occurred, this particular plaintiff would be able to work until the age of 40 in a sedentary position, in a sitting position, and then she will have difficulty working a full day beyond the age of 50 to 55 years. Actually, what she's talking about is that she would have had difficulty had the accident not occurred. Oh, sorry, she'll have difficulty now that the accident has occurred. And then you've got your collateral information. Let me just deal with that quickly. Collateral information is information which is obtained from other witnesses, not sort of medical witnesses. And you'll see that the principal of the school was telephoned, and he gave a sort of a report on this person's ability to function. And that collateral information is also important and will emerge from the evidence and from the documents. So what you do then is you take that type of information and you try and work it into that model of what would have happened had the accident not occurred, what's the likely scenario, and look for that in your reports. What's the likely scenario now that the accident has occurred? And you also look at your past loss, which is loss up to the date of that report, and potential future loss. And you categorize those 4 areas. And then I'm going to just finish on the actuaries' reports. So once you've got the industrial psychologist reports, you will then have a look at the actuaries' reports. And the actuaries' reports will show you the actual rands and cents figures of all the various assumptions that go up to making up the different positions of the parties. And you'll see here future uninjured earnings, and the actuary summarizes that for you. Some people like to go first to the actuaries' report because it gets you straight to the rands and cents. That is a perfectly acceptable approach. You just then, if you do that, then go to the actuaries' report, take a step backwards, and have a look at the industrial psychologist reports. I quite like to start with the industrial psychologist reports because it gives me a general sense of the matter, and then I look at the actuaries' report as almost a continuation of the industrial psychologist report. Either way is fine, whatever you're comfortable with. And so you'll have your calculation of loss of earnings, future uninjured earnings, and that's quite clearly set out. So had the accident not occurred, what would the future earnings have been? And there they break it down into rands and cents. I like to work quite a lot with the actuaries' reports because they're normally very accurate and they're reliable, and actuaries are something like a computer. Once those assumptions go in, you can 99.99% of the time the figures that come out will be right. Then you've got your future injured earnings. So now the accident has occurred, what is expected in future. Another important aspect is your contingencies. So contingencies are basically what are the chances of them not earning that money, and that then gets applied, and they're basic percentages that apply. You'll see in this case what the actuary's done is he's applied 15% for uninjured. In other words, had the accident not occurred, what are the chances of that person dying or for some other reason not being able to earn the income which he's assuming that would have been earned? That he's pegged at 15%. And then injured, now that the accident has occurred, what are the chances of that income not being earned in her injured state? And he's made it higher at 25% because she's got these injuries and she may actually have a problem earning that money down the line. I think that 25% in this case is far too conservative, by the way. So that then gives you an insight into that aspect of the actuary's report. And then I'm just going to take you to the second page. Here's the capital value of loss of earnings, excluding the RAF cap. There's a cap on earnings. It does change from time to time. The actuaries will deal with that, and they should give you that information in their report. But you'll see that the way that it's approached is paragraph 4.5. So your future uninjured earnings, in other words, had the accident not occurred, would have been 5.6 million. Less contingencies, in other words, what are the chances of that income not having been earned had the accident not happened? In other words, there might have been another illness, the person may have died, there are various considerations. She may have lost her employment for other reasons. There's a 15% chance, so that's then deducted off the total amount, and in this case leaves you at 4.8 million rand. Then you look at the capital value of earnings, the injured earnings. What has she earned in her injured state? 287,500 with a 25% or future earnings of 287,500. 25% chance of her not actually earning those amounts in her injured state, and it leaves you with 215,000 rand. And you take the 215,000 future, it's injured in an injured state, so actually what you're expecting to happen, and you deduct that from the 5.671, which is what would have happened in the accident if the accident hadn't occurred, and that gets you to 4.6 million. And then I just want to show you this 4.6. It's actually not too tricky to deal with because the actuaries deal with this for you. But just to be aware that your capital value of loss of earnings, including the RAF cap after contingencies, there's a limit, and so they've applied it in this case. It drops the claim down to about 4.5 million rand. So from that 4.6, it drops down to 4.5, and it's actually reduced about 0.2%. So that then gives you a general working approach on how you start getting to the rands and cents differences between the parties. Now, this actually is for the plaintiff. The defendant will have an actuary who will calculate maybe on different assumptions. And so you'll check the assumptions that the actuary uses, and then you work backwards from that to your industrial psychologist, who will give you some of the factual information, either medical or collateral. And then back from that, if necessary, you can start that way. You can start looking at the medical information in particular, which can be challenging. And once you know what the industrial psychologist is assuming to be the case, which they sort of feed into the actuary, and then you know what the assumptions are, then you can start working backwards and saying, well, the industrial psychologist's assumption, for instance, on the possibility of the person not being able to work for another 10 years based on the medical facts, it doesn't look right. It looks like she actually would have a very good chance of working for those 10 years because of the report of Dr. So-and-so or such and such. And then that way you can start looking at the industrial psychologist's assumptions. Yeah.
We are now out of time. Can you please wrap up?
Sure, I'm about to wrap up, Herman. It'll be 2 minutes. So just to recap, what I would recommend you do instead of starting page 1 and working through to page whatever it happens to be, start off with either your actuary or industrial psychologist's report. Get to the figures that the parties are claiming, find the respective positions, and then once you've got those figures, start working out the assumptions that the industrial psychologist uses. So what factual scenario is the industrial psychologist working from, either medical or collateral, and that way go back into your medical reports and start checking the positions of the different parties. Just to finish, what I would say, and there was a comment made about how much time a mediation takes, and I've already said that takes a good deal of preparation to be ready to deal with matters of this nature. My estimate is that you should set aside a whole day or set aside 2 mornings to get on top of the information and to prepare properly as a mediator, especially in the beginning. If you're going to be dealing with these mediations with any level of proper preparation. And then the last point is develop those spreadsheets, make notes in whatever form, make notes of where the actuary is, work back to the industrial psychologist, and then make notes of the key medical points, and use your medical experts if you're a legal practitioner or mediator. So just in summary, that's a bit of an insight. I know it's technical, I know it's a bit challenging, and if you haven't encountered it before, it might seem a bit bewildering, but that is a suggested way to start grappling with the volume of facts and information that you're going to have to deal with. I hope that's of some assistance. Herman, I hope that I got that wrap up in the sort of time that you had in mind.
Very, very, very good. Thank you, Ian. Ian, thank you so much for what you've taught us and told us. What I would just like to extract the essence of what you've said is that it has become very clear from what Sheena has said, what Michelle has said, and what Ian has said, that in order to be an effective RAF personal injury mediator, you need to have mediation skills in your heart and in your mind. You also need to have a good understanding of how to analyze facts of a matter, which are largely medical, and to another extent in relation to employment and circumstances, etc. So you have to have a good understanding of the investigations, work, and reports that expert witnesses of all the different disciplines write. And thirdly, you've got to have a good understanding of the law and how to apply the law to those circumstances and bring that to a rational amount of money. So you need to be a mediator and a medico-legal expert and a lawyer. So we can't all be all those things in one. And that is one of the big reasons why, particularly in the pilot project, we make use of multidisciplinary procedures. And we don't only have a mediator and a co-mediator, we also have two observers. And that brings me to another important role of the observers. You will see in the way that we have selected the teams that we have considered also not only which observer needs to learn from whatever, but also what skill or competence the observer will bring that the mediator or co-mediator might lack. The last thing in that regard is that the mediator must know what he or she doesn't know, and must also be humble about that. And of course, that will assist him or her to ask the co-mediator and the observers relevant questions. But also remember that there are two lawyers in the room. So the mediator can also ask the representatives of the parties. Of course, if they disagree, the mediator can't resolve that. But if they agree, then it is okay for the mediator to accept what they say on any legal point by way of agreement. If they disagree, then your mediation skills come in. How do I approach mediation of this legal dispute between these two legal representatives? The other thing that became very apparent during Ian's discussion is it's not simple and it's not quick. And that was also made very clear by Michelle in terms of her admonishment to prepare. So one has to prepare, one has to read what it's about, and one has to apply one's mind. And it is not that we are going to tell the parties what the solution to their problem is. It is so that we understand what is clear and also what is not clear and what the differences are, so that we can ask the parties appropriate probing questions to help to focus their minds on the issues and come to agreement. What was also mentioned very clearly by Michelle and by Sheena is we must always be sensitive to when a particular question that we want to ask a party they might be reluctant to answer that openly in front of the other party. And so for that reason, we must use breakaway private sessions whenever we think it's necessary or whenever a party approaches us in that regard. You will see on your screens that Lee D'Souza is one of the panelists. Lee started off this project together with me. So Lee and I were the first two mediators in this project, and she has now the same exposure to date that I have. Lee is a very experienced plaintiff attorney, and as I've accused her of in SOMLA training, she's more of a human rights lawyer than an RAF personal injury lawyer by her behavior. And for that reason, also Lee is a very good mediator. So I've invited Lee to give comments from her experience in the past few mediations we've done, and any further tips or recommendations that have not been covered by Ian, Sheena, or Michelle. Lee?
Hi, Alan. Hello to everyone, and thank you for that. I think most of the content has been covered. There are a couple of things which I've just made a note of, and the first thing is that SOMLA's model of mediation is really of huge benefit, not only for mediator, but for observer as well. So I've sat as observer, I've sat as mediator, and you really glean huge benefits by sitting as an observer, not only as a mediator. For me, the mediation allows the parties to slowly analyze a dispute and to really get into the flesh of the matter without having the pressure of an imminent judge allocation. And it really is so glaringly different because of that. The dynamic is completely different. The parties are able to interact informally on a without prejudice basis, and it really facilitates a different type of interaction between the parties. Historically, there's been a huge amount of conflict between attorney and RAF, not with all attorneys, but many cases there is that animosity. And Sheena mentioned healing. And while that's a huge element of restorative justice, in this case, it's just as important. You can almost see the relationships transform as one progresses with the mediation. And the healing process in the sense of getting rid of the inherent distrust that currently exists between attorneys and the RAF. My experience with the RAF has been hugely different. They are keen on mediating. It's such a lovely space to interact on a much more informal level. The mediations have been good-natured, and there's been a genuine will by both parties, to engage in proper, fruitful, meaningful settlement discussions. One also has to bear in mind that our role as mediators is not to formulate opinions. It's not to pass judgments. It's a difficult one sometimes, because if you're sitting in an experienced position where you've done the work for many years, we always get a sense of possibly, where there are weaknesses in both sides of the cases, both plaintiff and defendant, but that's not our role at all. Our role is to facilitate meaningful dialogue between the parties. And I think that really must be stressed, that we're not there to pass judgments. So Ian spoke a huge amount about preparation. I agree with him 100%. I have my own memo system. Any candidate attorney who I've trained over the last couple of decades knows my memos very well. These memos can be used just as easily for merits as for quantum. One could also summarize the merits information just to get an idea of what's there. And it really is, for me, crucial so that I have a good idea going in of what the matter's about. It's also useful to look at pre-trial minutes. The court directives currently have prevented the filing of pro forma minutes. And now, if one looks at pre-trial minutes, there's a huge amount of information that can be gleaned in terms of what's in dispute and what isn't. So for me, I find that very important. Also important just to highlight, one is not necessarily requesting documents to be prepared for a mediation. The mediator is working on the documents that are available between the parties in the normal course. I do think there's huge use, especially if you're dealing with parties who are not familiar with the mediation process, is to request documents. We all know joint minutes are important, actuarial calculations are important. If we're mediating on merits, accident reports, witness statements, damage to vehicles, quotations for damage. There are a lot of documents which one finds helpful. And if one is dealing with parties who may not necessarily be used to the process, it's good to point this out because of the fact that it is without prejudice. One has to really encourage the parties to get into the mediation. Often we use side meetings because parties are very wary sometimes in the beginning to share information or share opinions, and side meetings or private meetings are brilliant for that. So those are the things I've found. But most importantly, in the mediation space is to try and often get rid of the tumultuous relationship that's been there between attorney and client. It's already been highlighted the accident victim is central to the claim process. And while there has been a lot of animosity that's been created over the last few decades, I think if one puts the accident victim at the forefront, one realizes how important and how crucial mediation can be, particularly with the crowding out of the courts. The last thing I want to highlight is Zoom competence. I spent the most constructive hour in the last month with Aslan Creative, just familiarizing myself with the way in which breakout rooms can be used. If one is going to participate in the similar project, it is absolutely essential that competence is developed before one goes into the mediation situation, whether it's with Aslan Creative or anyone else, just to spend an hour to familiarize oneself with the process. So Rule 41A is incredibly helpful if there are members of the profession sitting out there just listening. My suggestion there in terms of constructive input would be to formulate a list of matters in your practice and find the matters which are capable of finalization, prepare them in the form of a list. You can do a Rule 41A3 notice for all of them, put the claim number and the link number, put the RAF attorney's reference and the name of the firm, even though they're not handling the matter. Just make it as easy as possible for the Road Accident Fund to locate their files, and send a huge 41A3 calling for mediation, because it will help the Road Accident Fund get matters or get lists of matters ripe for mediation. So I think that's about all I've had to say, but the pilot project has been a fantastic experience. There's absolutely no doubt the fund is serious about mediation. They want to mediate. So yeah, again, for the attorneys out there, give it a try. It's going to be well worth your while.
Thank you very much, Lee. That was very valuable. We are now going to go to questions, but just before questions, I want to show you a document which is the schedule of mediations going forward and the teams that I have set up for those mediations. So you can look at the document and then give your comments on whether you think it's right or wrong, or whether you think we can improve it in any way. But just so that it's open to everybody to see, I'm now going to share that. We will also make this available, and I'm going to ask Janae, will you please, when we are finalized on this, place this document in the standard documents folder so that everybody who has access to that can see it. But also I think you must attach it to as an attachment to this chat, because there will be people who are in this meeting who will not yet have access to that standard documents folder.
Dr. Yedlin, I cannot share in the chat during a webinar, but I can put it into the standard documents folder as you requested.
All right. So let me ask Ashley. Ashley, is there a way that we can make this document available to everybody in this webinar?
I do have everyone's email addresses from their registration, so I can email the document to everyone.
Okay. Thank you, Ashley. So let me just explain to you then what the document says. You will see that for the first 6 mediations, the information is complete. That gives the date, the day of the week, the name of the claimant, the name of the plaintiff attorneys, and they're the mediator, co-mediator, and observers. Now, I broke our own rules for the first few mediations for a very important reason, in that, and this was with the consent of the parties, instead of having 2 observers for the first 2 mediations, I had 4. And then you will also see for another 2 mediations, instead of 2, I had 3. The reason for that was so that we could snowball this learning process faster. So if we had started off with 2 observers and all the way through, we would now, after 6 mediations, there would have been 8 people involved. and we would have now been able to split up into 4 teams. As it is now, after this round, we are going to be able to split up into 7 teams. And 7 teams means we will be able to accommodate 28 people. So that's what I'm showing you now. So for the first mediations, myself and Lee D'Souza were the mediators. Trevor Bailey, Susan Verhoef, Charlene Labuschagne, and Lance Marais were the observers in the first one. In the second one, Hasina Kasim was an observer, and also Susan, Charlene, and Lance Marais. Then the next 4 mediations that have already occurred, we had one team with Lee leading, one with Charlene leading, and one with myself leading. And there were our co-mediators and our observers. Now, in this round, in other words, the second round of the mediations, there are still 2 that need to be concluded. And they will be on Monday, 27 July and Wednesday, 28 July. And, sorry? Sorry, Wednesday, 29 July. So that will be Lee's team and Charlene's team. When those 2 are concluded, we will have concluded round 2 of the mediations. That means 8 matters will have been concluded. We are then going to break up into 7 teams, headed by Michelle Posman, Trevor Bailey, Lance Marais, Susan Verhoef, myself, Lee D'Souza, and Charlene Labuschagne. So in the third round, the first 7 mediations will be done by those teams. And there we can see the names of the observers that we're inviting to join those teams. So you will see each of these co-mediators has either been an observer or a co-mediator in the first 2 rounds. All the names here are the 14 new observers that we are inviting into this third round. And then exactly that same process will be repeated for the next 7 mediations in round 2. So by the end of round 2, we will have 28 people at least properly exposed to and experienced in this process. After that, we are going to go forward with a bigger group still. So I would like you to please find your name on this. First of all, confirm that you are happy to mediate in that team, that you don't have any huge personal conflict with any other member of that team. Because if you do, or if there's any real reason why the teams have to change, please let us know. But I must tell you that a lot of thought and also reading from your bio info that you've sent to Janae has gone into working out the teams in terms of balancing medicine, mediation, and law, balancing RAF, personal injury experience, balancing other aspects, and also balancing general experience in medical legal practice. So I think that we have the teams suitably balanced, but if there are any serious objections, please let me know. Now, we do not yet have from the RAF the identity of the matters or the attorneys for any of the further mediations. They have said they will let us know during this week. So as soon as we get knowledge of that, Janae will enter the matter and the attorney's name into there. And then Janae will send to everybody in that team, so Lee, Lance, Karina, and Hasina, she will send this information, and she will send the link to the documents folder for that mediation and the link to the standard documents folder. Then Lee will be responsible for checking with Lance, Karina, and Hasina that they are going to be available. If they're not going to be available, Lee has a problem, and Lee must either resolve that problem with them or come to us to see if we can't make a change. One of the ways of changing, let us say, for example, Karina says she can't possibly participate on Monday because her husband's having an operation. So one of the ways we could arrange is we then ask Karina and Carlene to swap around. So then Carlene goes on the Monday and Karina goes on the Wednesday. In this particular example, that would be okay because both of them are nursing consultants. However, if we have a different situation where, for example, here in Susan's mediation, say now Dr. Ferdi Poel says he can't mediate on that day. There's a reason that he's in that team because he's a pediatrician. So he can't just swap around willy-nilly with any other observer, and there are not many medical specialists with whom he could swap around. So if it is not easy to swap an observer around or a co-mediator around, the only other way we can do it, there are two other ways. We can say that Susan's team, which has to stay intact, swaps around with my team and we just swap the dates for those mediations. But that communication has to happen between the lead mediator and his or her team and any other lead mediator with whom you wish to swap, who will need to communicate with his or her team. If that cannot be arranged by swapping, the only other way is to say, well, sorry, Ferdi, if you can't be there on that day, then you're going to lose out on this round. And then we go to our list of other people that want to observe in mediations and we select a suitable replacement, which means that Ferdi will then come into the process at a later stage. So my plea to everybody is please do your best to make yourselves available on these dates so that the thing can work. If there's any reason why you can't be available, talk to your lead mediator and try to resolve the problem in that way. The other document I want to ask Janae to share, that is a written summary of something I mentioned early on today, which is just setting out for record purposes the roles and responsibilities of each of the participants, so that we know what the RAF has to do, what the mediator has to do, what the co-mediator and the observers have to do. Janae, do you have that document available for sharing?
I do, and I'm busy sharing it now. Just advise if you are seeing it. Where did it go? Wait.
We do see it, Janae.
Oh, good. Okay.
Right.
And if you need me to zoom in.
Okay, now I'm not going to read this document. I'll just scroll down, Janae, so that everybody can just see that the document provides roles and responsibilities for each of the participants. This covers essentially what I said earlier this morning. I would also like to ask Janae to put a copy of this document on the standard documents folder, and also ask Ashley to email this to all participants in this webinar together with the schedule. Ashley, is that in order?
Yes, that's perfect.
Thanks. Thank you, Janae. You can stop sharing now. Okay, we're now going to move on to questions. I have seen already a lot of questions in the Q&A function. Those which were of a relatively straightforward nature, I have been able to answer directly as the chat. But many of the questions go to the heart of mediation. And for those questions, I would prefer the person asking the question to come on and to ask their question so that we can hear them and, if possible, see them. Ashley, is that possible?
We can, so how it'll work is I will call on the person. I've got a list of people that you've asked to ask their question live. So I will call on that person, allow them to speak, but we won't be able to see them. So their videos won't be visible, but they need to unmute themselves once I've given them permission to speak, and then we'll be able to hear them.
Okay, that's fine. So we'll be able to hear you, but not to see you. So a lot of the questions I have answered already in the chat function. Please ask this question live when we come to questions. Now, the sequence of questions, I'm totally dependent on Ashley because I can't monitor two processes at the same time. So Ashley, you will say, John Smith wants to ask a question. John Smith, please unmute your microphone, and then we'll hear John Smith. And then what will happen is, if I can answer the question, I will attempt that. But in most cases, I will ask one of the panelists to answer the question. So going forward, if you have a question that you would like to ask live, then please just write your name there and say live question. Then, so you don't have to type out the whole question. So when we get there, Ashley can just say, okay, Peter Pan, it's time for your live question, and then you ask the question live. Do all the panelists understand that? And are everybody happy with that procedure? Okay, I see nods. That's very encouraging. Except Sheena still looks perplexed. Sheena, is that acceptable to you? Thank you. There's a smile and a nod. Okay, Ashley, so who is the first question?
Okay, the first person is, excuse my pronunciation here, but Olimbunmi. You can unmute.
Hello, good afternoon.
Good afternoon. Welcome.
Yes, thank you. I just want to ask, how do I become a mediator? What are the training programs that one needs to undergo in order to become a mediator?
Okay.
And can you recommend any of the program for us?
Yes. I'm going to give you 3 names, and then I'm going to ask Michelle if there are any other names that she can give, because possibly she will be able to. So the 3 training organizations that we know, SAMLA, is Conflict Dynamics, Mediation in Motion, and ADR Networks. Can I ask Sheena, will you please put in the chat function for everybody to see the contact details, how people must contact ADR Networks if they wish to go to your training? Michelle, can you please put there the details of Conflict Dynamics? And Ian, can you put the details of Mediation in Motion? And then I will ask Michelle, I know that there are other legitimate training organizations which I don't have personal experience of, so could you please answer the rest of the question?
Sorry, Harold, I was just calling it up. So all of the information that you need is on DISAC's website. It's disac.coza. They indicate there who the accredited service providers are and which are the accredited training courses. So Herman was quite right. Conflict Dynamics, the Royal Institute of Chartered Surveyors, the Mediation Company, the University of Cape Town, and LEAD, LSSA LEAD, which is the Law Society. So any of those organizations, in addition to the ones that have been mentioned.
Thank you. Michelle, can I then ask you to put in the chat function the URL for the DISAC website so that people can go there to get information? Thank you very much, Michelle, and thank you, Olabunmi, for that question. Ashley, who is the next question?
Dr. Henry Lerma's next. He has a couple of questions, so we can address them all at the same time, please.
Yes, welcome, Henry, and I'm very honored to have you in this training session. I must say that Henry is the deputy chairperson of SAMLA, and he and I are very old colleagues and friends. And also, Henry and I had the fortunate experience of successfully mediating the merits of a complicated CP matter in East London. So Henry knows what he's talking about. I also want to make use of this opportunity to congratulate Henry on his ascendancy to the title of Professor Henry Laram. Congratulations, Henry.
Thank you, Herman. Thank you very much. And I want to compliment all those who have taken part in this auspicious occasion. My first question goes to the heart of ingredients. Now, I'm not a baker, but when you speak to a baker, they usually talk about key ingredients. The question is, what are the key ingredients for successful outcomes in mediation? That is number one. That's the first question. The second question goes to the aspect of quantum. Now, Ian alluded us to the fact that there seems to be a difference in the standards applied when it comes to contingency aspects. Now, if my observation is correct, should we not aim to work towards a more uniform approach to applying contingency standards? Thank you.
I'd like to ask Ian to answer that question, Henry.
Do you want me to deal with the second question first? You had one?
Yes.
Henry, there is actually a rule of thumb that is supposed to apply in assessing contingency. It is a bit of a rough guideline, but it's supposed to be 0.5% per year. Look, that's a guideline, and let me say that in and Helen, I think Lee must also just contribute here, because it's a lot of this is a kind of feel as you go forward in a matter. And contingencies, Henry, it's a good question, because contingencies often are sort of the last sort of piece of the puzzle that falls into place. And I found over the years that I'm not exactly sure why it is always, but it seems that the parties battle to find each other on contingencies, and they deal with far more difficult matters, and then they hold out on contingencies. And there was a time, in fact, Lee, I'm sure you're aware of this as well, where the legal representatives would sort of agree everything about the matter, but the legal representative appearing for the fund would not be comfortable with going with an agreement, so we'd appear before a judge for an hour and argue contingencies just to get a judgment. It was a bit farcical, but anyway, so there is that 0.5% per year standard. I think contingencies, personally, I don't really think they're so difficult to agree. If you and your opponent have got the facts right, and it sort of goes to my presentation, if you do understand the general facts and you do understand what the position is, and if you can find each other more or less on those facts, then generally the scope for contingency disagreement, you can make a lot of progress on. Where it does become tricky is that there are certain matters where you've got like high contingencies that apply. So for instance, sometimes we looked at a matter recently where I think it was actually a mediation matter, where I thought this is a situation where it's all but impossible for this person to work again. And you'll get some sort of indication from your expert that it's highly unlikely that the person will work. And then you're looking at something like a 90% contingency. And there I think that it often does, you'll end up settling at 40%. I think it actually happened in that matter. And I thought wrongly so, but that is one thing that I would say where contingencies can become contentious. Lee, what are your thoughts on that?
Yeah, I think what I found over the decades is that what happens is once the parties look at the figures rather than the appropriate contingencies. So my take on contingencies is to actually forget about the figures for a moment, because there are very specific contingency factors that one looks at. In terms of vulnerability, in terms of the information we get out of the medico-legal reports. So Ian is 100% right. It is common practice to look at 0.5% a year. And if one looks at post-morbid vulnerability, one would then raise the post-morbid contingency. But there are many other factors, and things that we get out of the medico-legal report, which we then use to apply appropriate contingencies. It goes without saying that the more vulnerable an individual is, the higher the post-morbid contingency would be. I also just want to address very briefly probabilities versus possibilities, because often you have scenarios that are provided by industrial psychologists, we're dealing with a balance of probabilities in court, but there are sometimes possibilities of further progression by a victim, whether that be pre or post-morbid. And then one will use the contingencies very often to cater for those possibilities rather than formulating a calculation on that particular aspect. So there's a lot that goes into contingencies, and Ian is right. It is definitely the bugbear in an assessment. But I agree with what he said. Yeah.
Herman, can I just quickly respond to Lee just very briefly, because I think contingencies do come up a lot, and yeah, just the one point there, Lee, that I just really agree with is contingencies can be used as a way of almost landing the aeroplane. So you can sort of fine tune your agreement based on contingencies. That point about probabilities and possibilities is a very important one, and I think people who do deal with this type of work must just take the trouble to be really clear about the sort of the civil standard of proof, which is a balance of probabilities, which is your overall standard, and then applying a finer kind of tuning to the actual settlement process, which means that you could then go on even fairly remote possibilities could be brought in that way, and contingencies is a very handy way to do that. No, I agree completely. Thank you very much, Ian, and thank you, Lee. Michelle, can I ask you to respond to Professor Laram's first question?
Sure, Herman. The first thing I'm going to say is preparation for the key ingredients for success. Very important to know both sides of the matter. And then other than preparation, I would say a willingness to collaborate on the part of all the parties, a commitment to resolution, and flexibility. I would say if I had to pick, those would be my four primary key ingredients. I don't know if anyone wants to add.
Sheena?
Michelle has said it all. I would just add that the number one skill for a mediator to develop, and I think again it's lifelong learning, is the ability to listen, open-hearted listening, and engaged listening. So I would say it's the top skill of a mediator to develop and work at and be conscious of working at.
Herman, can I just make can I make a comment there, Herman, just specifically with the mediations that I've observed? One of the key skills that I think in getting these mediations to settlement is perseverance. And in fact, even to not just at first blush allow the matters to be postponed or that there can't be a settlement. I've watched now, how many, three of these and an MEC one. And in each one of those, there was an initial attitude, almost as if let's kick the can down the road. And I would just encourage mediators and you need a certain confidence to do this, but not to just accept that that's the position. This matter is not ready for mediation. There's one in particular where both parties thought it couldn't be mediated. And Herman, I don't want to embarrass you, but I want to tell you that Herman was confident. He pushed the process along in an appropriate way, and that's important. But don't sort of be timid. You know, we have to. There are times when the party should be pushed, and there are times where you just sort of almost don't take no for an answer and find a way to keep the parties talking, keep them at the table, and start steering them towards a settlement. And Herman, I don't know whether you want to do it right now, but I would be very interested to hear from you the sort of process and the way you approached that issue. And why I raise it in particular is because I think it's been a common. I've observed it sort of it's coming up regularly in these mediations, and I think we do need to start having some insight into how to deal with that particular issue.
Well, thank you, Ian. I'm quite happy to share my experience. The thing is, just like all of us who've sat in roll call court know, parties come to court and then one or both parties try to find a reason to run away and not to conclude the matter. And exactly that same thing is experienced in mediations. So I have considered it my role to do my best to encourage the parties to stick together, to actually deal with the issues and actually try to come to a solution which they are happy with. And I've experienced wishes to run away both from plaintiff side and from defendant side, of course, for different reasons. And essentially, the way that I've dealt with it is the way I deal with almost everything in mediation, by asking questions. Because when I ask somebody a question, I'm not telling them what to do. I'm also not telling them what the answer is. I do know the difference between leading questions and open questions. So I ask open questions. But my questions are designed to focus the mind of the person on the issue at hand, or to focus the mind of that person on a particular aspect of the thing at hand. And often in applying their mind and thinking about that, then a realization comes in, and then another question and answer, another question and answer, and then the person has considered the elements that I've considered. And having considered them, often comes to the rational conclusion that anybody would come to if you apply your mind to each of the necessary steps. And sometimes, of course, depending on sensitivities, those questions have to be asked in private session, and at other times those questions can be asked in open session. But it's essentially that, Ian. Asking questions to try to make people, if they want to do something like run away, they must explain to you what the reasons are that they want to run away. It's like a fundamental principle of everything to me in civil litigation. You want to convince the judge to find in your favor, you've got to explain to the judge the reasons for doing that. An expert witness provides expert opinion, which is actually a conclusion, and must assist the court and the parties to understand the reasons for coming to that conclusion. So to me, it's the same process.
Thanks, Adam.
I just want to ask Henry, did that answer your questions?
Yes, indeed. So thank you very much for that.
Okay, thank you very much, Henry. Ashley, who is the next person asking a question?
Donnie Vederman.
Donnie Vederman. I want to welcome you, particularly Donnie, because you and I have sat on opposite sides of the fence, you as an attorney and me as a witness, on many occasions, but I've developed a huge friendship and also trust and respect for Donnie. So thank you very much, Donnie, for bringing all of your experience into this mediation project. Please ask your questions.
Thank you very much. Can you hear me?
Yes.
No, thank you very much, Herman. Yes, it's been many years on opposite sides of the fence, and I sincerely look forward to the first mediation that I'll be doing as observer with you. I think we have the ability to walk a long walk together. My question, Ian, is to you. Looking at the brief extract that you've shared from the medical legal report of the industrial psychologist, my instinctive reaction is that it's incomplete. The combination or package of the income and the possible collateral information suggests that this is a government employee, possibly a teacher, and that medical boarding or some form of medical disability would flow from that package of income. That clearly would have a tremendous impact on whether reduced hours would have a financial implication and or whether the post-income income is correct. Now, how do you deal with that in a mediation without telling the parties that you think the expert's report is incomplete, or telling them what your views are of the value of the report? How do you approach it?
Donnie, I don't know you. Sorry, have you finished?
Yes, thank you.
Donnie, I don't know you directly, but I see that Herman's respect for you is well founded, and I look forward to engaging with you in future. Donnie, there's sort of two questions locked up there. The one is a sort of more of a technical one, just on the medical boarding aspect, which of course is important. In fact, in this case, it wasn't a government employee. She was employed at a private institution. I don't want to give too many facts because it is confidential, but or I don't want to tread on toes. But she was privately employed. But that's not really I think what you're making a very important contribution here, Donnie. you know, what is the role now of the mediator? Let's say you do spot something like that. Now what's the role of the mediator? Do you take those parties to one side? Let's say they're going to settle and you're concerned they're going to undersettle by, let's say, R1 million, because you think that they've missed something. Now, so what is your role as a mediator? Are you supposed to step into that settlement and let it happen, or not let it happen? Or are you supposed to just take a party to one side and say, look, there's an error that you're making? I think that's a particularly challenging ethical question. And I think we need to. I don't have a very clear answer to that. My instinct and my general approach is that in this sense maybe you adopt more of a judicial role, and I would say this that it very much depends on the facts and circumstances. Now, why I say you sort of adopt a judicial role is it you know, you don't know what's going on with the parties. And I would be reluctant to get too involved in derailing a potential settlement. But having said that, if I saw something that was seriously remiss, I think the correct approach to take there would be to bring that to the attention of the parties in some manner, and to through some sort of process of not evaluating and not dictating what the answer is, but to get the party that's making the mistake to think about their reasoning. And obviously there's a point beyond which you can't take it. But I wouldn't like to just stand back and watch an undersettlement happen. I would prefer to take that party aside in a breakaway, and I'd be very interested to hear other views. It's not as if I've got the full answer here. I'm just sharing my approach. But I would be inclined to be fairly proactive here and get that party into a breakaway room and say to the party, look, you are considering the settlement. Can you take us through those steps of how you get to that figure? And let them go through 1, 2, 3, 4, and maybe say to them, look, you might just want to give some thought to that. You have a look at those steps more carefully, and let them go back and work it out for themselves. This issue came up in one of these mediations, and as it happened, when the parties actually settled, I could see that actually the issue wasn't as real as we first thought it was. I don't want to go into details, but it sort of disappeared. But the possibility of that came up. Now what I would like to do, Donnie, is I'd like to now start calling my witnesses to in my position. So if any of the panelists would like to contribute, and please, I mean, if anybody feels that I'm wrong or they have a different view, you know, make the points. Let's talk about these things now.
Well, thank you very much. I would like to invite Lee, because Lee was involved in a particular issue that was very difficult or tricky in this line. So Lee, do you wish to make any comments?
Yeah, sure. Like Jens said, it's a really difficult thing. And I think if one puts the parties at the forefront, we have an accident victim who we don't want to be undercompensated, and we have the road accident fund who we don't want to see overcompensated. And it is a very, very difficult position for a mediator, but my sense is the same as Ian's, in that if one sees that a profound injustice is going to happen if this matter is finalized, that I feel, and it's something that I have actually discussed previously with Marion Scher of conflict dynamics, because I also have a difficulty with it. But my feeling is, in the case of a profound injustice, I would rather say something and possibly even withdraw as mediator. You know, it's incredibly difficult, but that is possibly what I would do. But it depends on the extent of it. You know, we all know that there are some experts who are very conservative and some that are very liberal. And one has to look at that. But if it's something that surpasses that, for example, if I see a matter where there is really, really a significant, for example, a brain injury, where the wrong expert has been briefed, you've got a clinical psychologist who hasn't conducted proper psychometric testing, and it's very clear that particular injury has not been investigated, I would say something. Just my feeling. I don't know what's right and what's wrong.
Yeah, Lee, if I can just underscore what I would say is the way you approach it is probably important as well. So my sense is I'd be reluctant to just express a view. I agree with the points, but it does depend on so much on the facts. But maybe sort of that's where people need to think about being slightly creative and get the parties to think it through for themselves. It would be preferable if they could reach that conclusion themselves. Sorry, Herman.
Agreed.
I want to give you a little example without disclosing anything confidential to the parties, but where exactly this thing occurred. Dani, we had one of the matters in which the actuarial report was patently in error. And the nature of the error was that for future earnings having regard to the accident, the actuary had exactly the same figure as in the column for future earnings but for the accident. And when we looked at the facts, we found that the person had in fact been unemployed since the accident, and according to all the experts, there was no prospect of him having any employment. So there was a figure entered by the actuary for future earnings which were pie in the sky. They would never materialize. We discussed that amongst ourselves, myself with the co-mediator and observers. We discussed that to be aware of it. Eventually, as it came out, it didn't make that much difference. And the reason was because of the age of the plaintiff, the remaining years of life made that a relatively small amount of money, considering also the contingencies that had changed the rand value of the figures. And when you look at issues like the general damages agreement, etc., it really seemed to be a fair settlement. Because if you had a bit more money here and a bit less money there, it would also have been fair. So we felt it was fair and reasonable for that mediation to settle in the terms in which it settled without raising an objection about the actuarial mistake. There was another matter which I couldn't tolerate, and I won't give you any details about that, but simply to say that in a certain matter, I came to the conclusion that there was a very profound misassessment by all the experts. And because of that, if that matter were to go ahead and be mediated on the basis of those reports and actuarial assumptions, it would result in a grave injustice, particularly not only insofar as the money, because that's one thing, but the most important consideration to me was that by all indications, this person was not fit mentally to instruct his attorneys and was not fit to sign a contract and was not fit to manage his own finances. So in that matter, I had to take the difficult step of saying to the parties, I'm going to give you my opinion, and having given it, I'm going to withdraw as mediator and somebody else will take over. So I told them that. I said, I think this matter isn't ripe. It has to be properly investigated. So we actually had both of those experiences here. Both of them were difficult, but that's how we dealt with them. But let me also say, this is also why we are bringing in so many, and we're so happy to have experienced people in all of the various disciplines to come together, and we hope that everybody shares their experiences with everybody so that we can all learn together. Dani, does that answer your question?
Thank you very much, Herman. That's very helpful. Thank you.
Thank you.
I look forward to August.
Okay, Dani. Ashley, who is the next question from?
I'd like to call on Dirk Pretorius next, please.
Dirk, will you ask your question?
Yes, actually, thank you so much, Dr. Edeling, for today's session as well. Just a question, what Dani touched on. I think what we're going to see in future, when a medical expert steps out of his shoes as a neurosurgeon or industrial psych, whatever it may be, into the role of a mediator, it's going to become difficult if those aspects that you've discussed now arises, because you've signed to be a facilitative mediator. And you are breaking the contract the minute that you start giving your opinion, but then again you have the obligation also to note out and to note to the parties if you see something that is amiss. For instance, as a neurosurgeon, you might not pick something up in the OT report or in the industrial psych report that is wrong, but on your own field of expertise, how do you stay impartial if you see the neurosurgeon that was appointed, specifically when there's only one, for example, neurosurgeon report that both agree on, and you see something maybe an x-ray that has an old injury on it or something that's pre-existing that they did not pick up on. So I think, to my mind, the challenging position between your own ethical obligation independently as a medical expert, and then you can't really step out of those shoes and suddenly be a mediator and forget about your position as a medical doctor. To my mind, it's almost like when you're on an airplane and someone has a heart attack and they ask for a doctor, you sit quietly. So I think that is something that we need to discuss and set some kind of guideline for if those things do arise.
Thank you, Dirk. May I ask, what is your discipline?
I'm an industrial psychologist.
Thank you, Dirk. Look, you're perfectly right. This raises a professional ethical issue. So you are correct. According to the rules of mediation, the teachings of mediation, and according to the agreement between SAMLA and the RAF, mediators are not allowed to give opinions or advice. Though, let's call that the rules. Sometimes one is faced with a situation where you cannot in good consciousness abide by rules because there is something that you see as so important that you have to break a rule. Now, if you break a rule, by breaking it, you render yourself unfit to participate any further in that process. So that is why, on the occasion that I thought it was necessary on ethical grounds to break the rule in the interest of the human rights of the person involved and in the interest of justice, I realized that that disqualified me. So that's why I broke the rule, and then I disqualified myself and I stepped out. Now, when is the ethical dilemma so great that you should break a rule or speak up when otherwise you shouldn't? Now, as you know, whatever other neurosurgical report I read, I will find something that I disagree with. And whatever other industrial psychology report you read, you'll find something you disagree with. Now, what helps me personally here is experience in the medico-legal issues of clinical negligence litigation. And what I'm referring to is the principle that the South African courts applied to clinical negligence, that the doctor is not held to the standard of the best medical practice. And in fact, the doctor is also not held to the standard of average medical practice. The doctor is held to the standard of reasonable medical practice. And the particular question the court asks in making a decision about factual negligence, did the action or inaction of the doctor comply with that which could be reasonably expected from a doctor of similar training under those same circumstances? And it is only when the deviation is so great that one considers it to fall below what can reasonably be expected that then, as a medical expert, one says, in my view, this action was below the standard to be expected of this kind of doctor in that situation. Of course, once an expert has said that, that doesn't equate to negligence, because there may be other legal considerations the court takes into account. But what the court wants to know from a doctor is, in your view, was it good? Was it okay? Was it maybe an error of judgment, but not unreasonable? Or was it so bad as to be unreasonable? Now, in a similar vein, although the circumstances are completely different, the context is different. In the same vein, when I, for example, in writing a pre-trial joint minute, having a meeting with my colleague, I don't agree with everything he or she says. But whatever I can live with is much better for me just to agree than to have days in court arguing about something that is trifling or maybe a personal interest or whatever. So my view is, whatever is okay, I would rather agree with than and get it out of the way as an agreement. But that with which I cannot live, I have to state my own opinion. Now, using both of those as a background guide, because this was the position I found myself in, is this so bad that I won't be able to sleep at night for letting this thing go by? Will I feel that I have been unethical towards the human rights of that person? And that's when I decided to speak up and break the rule. But if I see, and I am a neurosurgeon, if I see this neurosurgeon says that, okay, I don't think it's quite right. That one says that, okay, I wouldn't say exactly that. But both of them are within the bounds of reason. Then my opinion doesn't come into it. When I ask questions as a mediator, my thing is to ask them, what do you as plaintiff and defendant understand that neurosurgeon's opinion to be? If they don't understand, I will ask questions to assist them to understand the heart of that one's opinion. Then I will say, what do you understand that one's opinion to be? And until they get, and we all agree, this one says this, that one says that. My next question will be, what in your view is the reason for that disagreement? Is it because they've referred to different sets of facts? Is it because one has referred to 3 facts and the other one has referred to 10 facts? So let's go to the heart of why they disagree. And then you as parties can say, okay, no, we see that this neurosurgeon's views follow logically and naturally from the facts which we have, as parties have agreed. Or you can find that neither of them is right because there are significant facts we now know of which neither of them has taken into account. In some circumstances, that may be so serious, we'd have to halt the process and go back for further neurosurgical opinion. Or alternatively, that difference may be such that the neuropsychologists, occupational therapists, industrial psychologists can take those new facts into account, modify appropriately, and the parties can come to an agreement. So the simple answer is, unless I regard it ethically compelling, I don't convey to anybody my own opinion of any other report. I simply go to my understanding of what that expert is getting at and my understanding of what the other expert is getting at. Thank you, Dirk. What is the next question, Ashley? Ashley, we see your lips moving.
I'd like to ask Ayanda, please.
Thank you, Ayanda.
Hi, everyone. My question is around cost for the various roles that you'll be playing, because there's a role of a mediator, observer, and co-mediator. And are the costs differentiated based on the profession? And it's also worrying to hear that sometimes you might need to disqualify yourself. So the question will also be, what will be the cost involved there? Thank you.
Okay, so I'm going to give you the first simple answer, then I'm going to ask for better answers. The first simple thing is, in terms of the mediation pilot project, there are no costs because we're doing it free of charge. However, everybody has to consider what they are going to charge as fees going forward when they do professional paid mediations. Our standard off the cuff or baseline is to recommend that any professional person involved in mediation should charge the same fees that they would charge for doing their normal professional work, except for this proviso. Let us say you are an experienced occupational therapist, you're a senior occupational therapist, you earn so much. When you start charging fees for being a mediator, you are not yet an experienced mediator. So when I've been asked to do private mediations, I've said, well, because I don't have that much experience, I'm going to charge 50% of my normal professional fee. Until I feel confident enough that I've got enough experience, I might go to 75 and maybe eventually to 100% of my other professional fees. That is our rule of thumb. On the other hand, I have no doubt that the Road Accident Fund will be interested in prescribing tariffs for mediations. The provincial departments of health might also be interested in prescribing tariffs, just like anybody who has to pay for any professional service may wish to prescribe tariffs. Now, if You set your fee that you determine according to your professional experience, like you do for your other work, and the client has got a tariff. Then it's a free market. You must decide, are you going to work at their tariff, or they must decide, do they want you particularly so much that they're going to pay your fee if it's higher. Now, I know on the MIM website, where I've been listed as a mediator for years, they've asked me to list there what my tariffs would be. On the SAMLA website, I also list what my tariffs would be. So you can go there and look what other mediators have said. But at the end of the day, it's a thing for you as a professional person to decide, and then in any particular case, decide whether you're going to take the fee that the party is offering. Lee, what do you think about that?
Yeah, look, I think that's pretty much it. I mean, at the end of the day, the cost of a mediator will be very similar in that respect to the cost of an attorney. You know, one looks at qualifications and expertise. I just want to add one other thing, because I'm not sure whether Ayanda was possibly also talking about the pilot project itself. So I think just to make it clear that the pilot project, all the parties involved are acting pro bono. So when it comes to the pilot project, there is no charge for anyone.
Okay,
Ian?
thank
I don't know if Ian, I don't know.
Ian, any further comments?
No, I think you guys have covered it.
Thank you, Ashley. Next question.
Talia, please.
Hello, Talia.
Okay. Hi. Okay, so I have a few questions. Must I ask them all at once?
No, ask them one by one, because we've got a short attention span.
But
So
you can ask them one after the other. So as soon as it's been answered, you can move on to your next question.
Okay. So Ian was going through in detail with going through the different opinions between the plaintiff and the defense industrial psychologist. What happens when there is some information in the one report that's correct, that needs to be considered, and then other information that in the other report that needs to be considered, and you kind of have to merge it and make it into a new calculation and try to make it financially
Vehicle brought those facts to the table. Now, of course, in the mediation, there isn't a judge, but the parties are the decision makers. So my approach would simply be make both parties aware of both sets of facts and the different facts, and then as parties, they must agree, first of all, on the facts. And if they can agree on a particular set of facts, then it's easy to proceed from there and do the calculation.
Is there an actuary? Would there be an actuary available to do that?
Yes. Now, usually, but in these matters that are brought to mediation now, they are trial ready. So they have pleadings, they have pre-trial notices, pre-trial minutes, and they have expert reports and joint minutes. And they also have an actuarial report. So if it comes then to a question where the assumptions are changed during the mediation, it's relatively quick for whoever appointed the actuary to contact that actuary and say, please give us a fresh calculation based on these changes. And if that has to take any time, then the mediation can conclude on that day with the facts that have been agreed, and it is postponed for a day or 2 days for a calculation and then a final concluding agreement.
Okay, makes sense. And then how do you deal with conflicting information, conflicting opinions and disagreements when you're preparing for your mediation?
I think in preparation, Talia, all I do is understand what the different positions are and not form a view of which one is right or wrong. But I notice this industrial psychologist says X, that one says Y. Why does the first one say X and why does the second one say Y? So you might find the answer in the orthopedic reports or the neurosurgical reports or the neuropsychology reports or in the employment records. Whatever it is, I want to understand why they differ, because they must have reasons for their opinion. And then if one identifies what the reasons are, then one knows, let's say the difference is in the occupational therapy reports. Then one makes a note that in the mediation, the different positions or conclusions of the occupational therapists must be mediated. until the parties can come to a common understanding of the occupational therapy opinions, and from there can go forward down the rest of the road.
Great. One more question. What happens, Ian mentioned something that he had in the tab that clarify with IP, or you have further queries for a specific expert where you need more clarity. How would you deal with that in a mediation context?
Okay, I'm going to give a short answer, and then I'm going to ask Ian for the real answer. The short answer is that sometimes you can clarify it by studying the reports and talking about it with the parties, but it may be very real that one needs experts to come to a mediation. And I am very much open to the concept of inviting experts to a mediation. Now, if one can determine that potential need before the time, one can invite those experts to come and talk to everybody and work it out there. In other circumstances, it might be necessary to postpone the mediation or to suspend it and to come back with the experts and deal with that. But I would like to hear Ian's take on this.
Yeah, thanks. It's a very good question. So what happens when you prepare properly for the mediation as a mediator? There certainly may be occasions where it seems likely that having somebody give input will clarify a situation. Let me give you an example from that case that I showed you. There was an assessment of that particular plaintiff's income earning as at late last year, but the collateral witness indicated that there was going to be a reassessment and probably a reduced working capacity, which would be assessed during early this year. Now, we don't have any further information, and now we're already into the 7th month of this year. So if we were to mediate that matter today, it would be very useful to have the employer's input on that particular point, because it would have a profound effect on the amount which would actually be awarded in due course. So that information would be valuable. Now, as a mediator, when you spot that and there's no updated report, what I would recommend, what I've been inclined to do in those circumstances, is to make sure that, and you have to be careful to conduct this appropriately, but my view is that you should try to get that information to the mediation. I don't incline to the view that one should just be passive and allow the mediation to get to that point, and suddenly we realize that, well, there's a witness who could be called, who could clarify this point and then result in a settlement, but that witness is now in a meeting or not available that day, so we have to adjourn the mediation. I would far rather, if I could see that there's a likelihood that a witness would be called, try and set that up before. Now, I said you have to do that in an appropriate way, and the way that I would suggest that would be done would be through the various representatives, certainly not to approach the witness directly as a mediator. I think that would be completely inappropriate. But and of course, cover yourself, address it in writing. So in the form of an email to the parties, bring to the attention of the parties that there's this particular issue that's occurred to you, that it seems from the documents that you've been provided with that this issue is likely to become of some importance during the course of the mediation, and recommend or suggest to the parties that they consider either dealing with that issue directly between themselves or potentially having that witness available to be called at the mediation. So I hope that helps to answer that question, Herman.
Thank you very much, Ian. It certainly does. Talia, are you satisfied?
Yes, thank you very much.
Thank you, Talia. Ashley, who is the next question from?
JP.
JP.
Hi, thank you for the opportunity. Ian, you made a lot of sense about how you prepare. What I'd like to understand is, do you use any rules of thumb to help you to get that information clearly on the table at mediation? As mediator, I don't think you will make or present a summary, let's say, of exactly what the amounts are on which they differ. They surely need to do that themselves. But by asking questions, you can make sure that it actually comes onto the table. And I would like to understand what your rules of thumb are that you use. For instance, if you have a matter where the differences seems to be only related to money, then you might want to get that differences to feature early. Another thing might be the sophistication of the the participants. My understanding is that you need the plaintiff especially to be on board on what is said, so that the plaintiff can be on board. In such a case, one would probably like to rather deal with things in a side meeting where the attorney, for instance, can help that plaintiff. If you hear my rules of thumb, I'm looking for some guidance.
JP, I think you actually locked up in your question are absolutely the right answers. That the way you deal with, look, I think I must make this point, that yes, prepare thoroughly and understand the lines and understand the positions of the parties on the documents, but it is certainly not your role to start adopting a particular stance and imposing that on the parties. So what you want to do as a mediator is be in a position to guide the parties to finding their own solution. And the importance of preparing and understanding the facts and understanding the reasoning of the parties is to put yourself in the position of being able to explore and to facilitate a mediation and an agreement between the parties themselves. And so your point about that's done through asking questions is exactly right. And that's what you do. You explore the position with the parties, try to get them to maybe understand that there may be a difficulty, or for them to say that there's not a difficulty and you revise your opinion, but to get them thinking and if necessary, to shift their position and start moving towards each other. So I think that's important to make that point, JP. And that preparation is not there in the sense of the way that as an advocate would prepare. In other words, I'm going to promote that position and justify it. It's there to guide the parties. And if the best way to do that is actually go back to Rule 41A and that definition of what we're supposed to do when we mediate. And of course, the SAMLA guidelines also make this point. We're there to guide the parties to understand the facts and to analyze their own arguments and conclusions, and if necessary, revise that or shift their positions provisionally so they can find each other in negotiation.
Thank you, Ian. Thank you very much. Now, Hanneke has just drawn to my attention a very important fact that I would not have suspected with all the excitement going on today, but our 3-hour time allocation has passed. We've now been going for 3 hours and 5 minutes. So, Ashley, you agreed to give us 3 hours. I am willing and keen to stay on in this meeting to answer any more questions. And I will invite anybody else who wants to carry on asking or answering questions to also stay on. But Ashley, you must just tell me if you want to leave now, you must transfer the host function to me.
No, I'm fine.
Otherwise, if you find it interesting enough and you wish to stay, then stay until you want to leave. Is that in order?
That's perfect. I'm here to stay. We only have 2 more official questions, but I'm sure now that you've extended the time, we'll get some more.
Okay, so then I'm going to ask everybody to give me a 5-minute comfort break. So possibly we can all take a comfort break, but don't close your meeting. Keep it open so it's all attached. Can we just then come back in 5 minutes and then we'll take the next question. Thank you very much.
Actually, I see we've also got still over 120 participants, so I think it is worth just pushing on a bit. But you're starting to reach the point that you can answer these questions now, Ashley.
Just about. I don't know that I want to be, though, so.
I'll see you just now.
Perfect.
Janae, are you there?
I am here.
Have you given Ashley the 2 documents that she will send everybody by email?
I have given her one of them so far, which is the roles and responsibilities.
Thank you.
And
the other one is that schedule.
Yes, I'm sending that.
Okay. So Ashley, Janae has sent you already the roles and responsibilities document.
Yeah.
And is now sending the schedule document, which you will send to everybody.
That's perfect.
I'm just going to send the schedule as a PDF, if that's okay.
That's fine. Yes.
Okay.
That is correct. Ashley, are we back now?
We've got 1 minute left since you said 5 minutes.
1 minute left. Thank you. I see we are now down to 111 participants. So there are still people who wish to ask or listen to or answer questions.
There are.
Thank you. I see that Lee is back.
Hi.
Thank you, Lee.
I'm also back.
Ian is back. Henry is back. Okay, so Sheena said she had to go, and I think Michelle said she had to go. But I'm sure that Lee and Ian and Henry will assist me in answering any questions.
Herman, I was saying to Ashley, don't forget Ashley, she can also start answering these questions now. We're going to draw her in.
Yes, of course, that's quite right.
I concur.
I can also tell you that by now, Janae is quite the medico-legal expert.
Yes. Absolutely.
Okay, we're good to start. The next.
Who is the next person asking a question?
Brigitte.
Brigitte, are you there?
Hi, I'm here.
Please ask your question.
Hi, I'm quite a keen mediator. I did the Mediation in Motion course in December. I'm a member of ADR Networks.
Yes.
I'm an advocate, but I only have criminal experience, and this seems to be quite technical in its application, and certainly way more advanced than sort of family law mediation. Are there any courses that one should do beforehand before registering for the project? Because we might not have the experience that's required in civil or medico-legal mediation.
Yes, certainly. Thank you for that question, Brigitte. So the thing is that we conceptualized this project starting off with experts or lawyers who were well grounded in medico-legal litigation. But those people are not going to be enough to handle all of the mediations. And so we welcome people who come from different backgrounds, but are willing to learn how to apply their skills in this context. So the courses that are available are through ASLIN. So you see Ashley there is of ASLIN, who provide administrative services and logistic and technical services for SAMLA. The big course is a foundations course in medico-legal practice, which is really highly to be recommended for anybody wanting to engage in medico-legal practice. In that course, we dealt with legal aspects that are particular to medico-legal practice. We dealt with logical reasoning, ethics and morality of medico-legal practice, and we dealt with specific issues in medicine that are relevant to controversies in medico-legal practice, and specific issues in allied health sciences that are specific to medico-legal practice. So it's a very good course. The whole course was recorded, and if you sign in with ASLIN and you do the course for study in your own time, at the end there's an online exam with UCT and you get a certificate from UCT for having passed that course. So that is highly to be recommended. The other one is that we have a number of follow-up workshops. So there's one about brain injuries, there's one about RAF and RAF4 issues, but there's a particular one about mediation, medical mediation. Now, the medical mediation workshop, because of limited time, dealt with an example of clinical negligence. So it dealt with mediation of negligence and causation in a cerebral palsy matter. So those are the workshops that I can really recommend.
Okay.
In addition to, or apart from that, as an advocate, if you read the SAMLA Guidelines and Protocol for Medical Mediation, which you will understand well because you are a trained and accredited mediator, you can also see there how we do things.
Yeah.
And then if you come into a mediation as an observer, then you will see how it's done, and then you'll progress to co-mediator and mediator.
Okay. Thank you very much.
It's a pleasure. Next question, Ashley.
Next up is Johan van Villek.
Hello, Johan. Welcome to today's meeting. Please ask your question.
Hello, Herman. You alluded to, and there was also a comment in the chat box about potential litigation against mediators. I was taught that after the mediation, you destroy all documents after the agreement has been signed. But what happens now in case of litigation in the future against the mediator?
No. I'm going to ask Ian to answer that.
Herman, what I would say is this: look, Johan, this is an emerging profession. Firstly, and so one has to. Sorry, I'm being asked to start my video. I'm sorry, my video is not on because the screen's giving me some problems. Thanks, Ashley. So, all right. So this is an emerging profession. I would draw the analogy with there's some developments overseas, particularly in the UK, regarding litigation brought against expert witnesses and the circumstances in which expert witnesses can be successfully sued for negligence. And I won't go into too much technical detail, but I think the bottom line is that where an expert witness does not act reasonably, and in fact we're starting to see that happen in South Africa as well. We've had a number of high court cases where that's being foreshadowed. When an expert witness does not act reasonably, in other words, acts negligently, there is the potential to be sued. Now, I would say that as an emerging profession, mediators would be subjected to the same standard. We've got a little participant there, it's quite cute. But anyway, so mediators would be subjected to the same standard. I'd go back to an earlier answer that Herman gave when explaining an approach to be taken as to when you intervene in a matter. And again, it's that standard of reasonableness. So that is the key, and that's always the benchmark that you apply to any professional. It doesn't have to be a healthcare professional. Profession could be any professional. And particularly with regards mediating matters, the point is that potentially, yes, you could be sued. I don't think we must make any bones about that. I personally think that the prospects of that happening, if you conduct yourself appropriately and you conduct facilitative mediation, and you don't get into a situation where you're prescribing to the parties, I think those prospects are remote, but nonetheless they exist. The last point that I would make on that is that I think that today has been an object lesson in why it is important that if you're going to take on this work, you must appreciate you're taking on work as a professional. You're going to be held to a professional standard, and it is very important that you equip yourself to conduct yourself as a professional. And that to my mind consists of three things. There's your personal conduct as a professional. There's the technical skills and understanding and training that you should take the time and the trouble and the money to participate in, so that you've got the hard skills. And then the third aspect of that is to belong to a community and to belong to an organization. And I think that Herman must actually be congratulated on arranging this today. And this is exactly the type of event that gives professionals the type of support that they need as this profession emerges. So I'm sorry it's a slightly long answer, Johan, but I think it's an important point. And I hope that helps you.
Herman, may I come
Thank
in
you
here?
very much. Just, yeah, what I just found about Johan's question, and I'd like to ask Henry, is Johan said that documents have to be destroyed after mediation. Can you give a comment on that, Henry?
I haven't come across that one needs to destroy the records. I would suggest, and this is because we are developing type of jurisprudence, I would suggest that the following be done. We should write it into our protocols that records should be retained for maybe 3 to 5 years, similar to attorneys who has to keep records. And we as an organization that drive mediation, we should perhaps incorporate that in our protocols as I suggested.
Thank you, Henry. I'd also just like to ask Lee about this. I might have a very simplistic view of this, but when we do an RAF mediation, it is a matter that has already been taken up by a plaintiff attorney against the RAF as a civil litigation matter. And what would happen if that matter had gone to the court and been adjudicated? Would people then have to destroy the records? Or what would normally happen? And whatever would happen, if that matter is settled through mediation, how does that change, if at all? What will eventually happen to the documents?
Herman, I think from a mediation perspective, the less record of the mediation, the better. It's without prejudice in nature. And you will find, that many mediators don't keep records. As a pilot project, it's a bit different because we're having the, there's a lot of information that the RAF as well wants to have, to study how the process has gone. But traditionally, one's not going to have records of the mediation per se. That's not really, so there's no recording function of the mediator. Ian? I mean,
what I would say, sorry, and I didn't deal with this point, Herman. I got a bit distracted there by Robin H's 2-year-old.
Can I just come in, and I'm going to ask you to follow.
No problem.
When we talk about destroying records, we have to be specific about what records are we talking about, because the people come into the mediation with hospital records, expert reports, notices, joint minutes, etc. So are we talking about those records? Because that's what I understood Johan to mean by records. And I think what he is referring to is whether records are generated inside the mediation. Now, in the mediation, we don't record what is said. We don't record what is conceded. We don't record the arguments or the discussions. Of course, if the mediator wishes to, for his own learning or his own future protection, wishes to record his own private notes, which he keeps privately and doesn't share with anybody else, I'm sure the mediator would be entitled to do that. But I don't think any record is generated other than the records that come into the mediation. Ian, can you finish that off?
Yeah, one point that I do want to highlight is that one has to draw a distinction between the sort of substantive content and obviously the records related to them if you do develop records, and the procedure which is used. And why I make that point in particular is because one possibility is that there's, if a party is not satisfied with the outcome of a mediation later, is that the mediation is reviewed. In other words, that one must look at the difference between what the actual substance and the what is happening between the parties as far as content is concerned, and how you get to that process. Now in the pilot project, we have a very, very strong record of what's happening, and I take great comfort from that, because that record to me is a strong defense against an allegation that some sort of improper procedure was used. I think going forward, Herman, there would have to be some thought given to this. I think Henry's point about a protocol is correct. For present purposes, I feel that more than comfortable with what we've got in the pilot project. But I think that we must always bear in mind that, you know, once we finish this pilot project, you know, you then go on to a next form of mediation. We don't have that additional structure, which are the pilot project administration documents. And I think it would be a good idea to at least be able to record the sort of process that is followed, to be able to demonstrate that Rule 41A has been complied with, in that it was a proper facilitative type of mediation. And just to finish, just the last point is this actually does tie in with points that have been asked about and debated about whether we should get involved in advising parties, etc. To me, that's a procedural type of issue. And once again, the yardstick is Rule 41A, sub 1, the definition. And I do think, Herman, that we're going to have to give some thought and put some effort into, once we finish the pilot project, giving guidance as to what is recorded to demonstrate that the appropriate procedure was followed. Just on the destruction of documents, can I just say this, that the documents that are prepared, I always keep, as an advocate, I keep records of those documents. It's amazing how it comes up some years after the event. If you are making handwritten notes and that type of thing, they talk about those documents, I wouldn't destroy those. I'd make sure that those are actually kept safely, obviously that they're kept in confidence, but I definitely wouldn't destroy those documents, I'm sorry to say. That's my view.
Okay, so Ian, thank you very much for that. So Ian, Henry and Lee, I think your answers were very helpful.
I'm still a bit confused there, man.
Just hold on a second. Sorry, Johan. Johan, I want to give you a job.
I think that nothing that is said in the mediation is for public knowledge, and it can't be taken to court later. And I was mainly referring to little handwritten notes that mediator would make for himself after individual consultations or joint consultations, just to make sure he doesn't get his facts confused. Because I was taught those things get destroyed as soon as the agreement is signed.
Okay, now I think the answer from Ian, and I think from Henry and Lee is the same there, that whatever notes you make for yourself, Johan, you keep for yourself as long as you maintain the confidentiality. So you can keep them for your own records.
Right, but they may in any case never be divulged in court in the future, because that will defeat the whole purpose of the confidential mediation.
Well, you see, the confidentiality and the without prejudice is that the party can't rely on what the other party said in that matter. But if a party is now going to start a new cause of action and try to attack you as the mediator, I think your rights are just like any defendant who's attacked for any reason. You can refer to any information that is relevant to your defense.
Could I just step in there as well? It wouldn't be a case of the mediator being subpoenaed to a trial. Traditionally and historically in mediation, the mediator cannot be subpoenaed by the parties at a later stage to come lead evidence at a trial. So if you're talking from that perspective, you know, unless some sort of case law precedent changes that in future, you're 100% right. Mediation is confidential and without prejudice in nature. And that being the case, the mediator would play no role in a trial situation on the same matter in the event that deadlock is reached.
But Lee, what I understand Johan's point to be, that matter is settled and done and dusted, and then next year, one of the party comes and sues the mediator for professional negligence for presiding over it under settlement. Now the mediator becomes the defendant. What would then be the position on confidentiality of the notes the mediator made for him or herself in the mediation?
Herman, can I just contribute here? Herman, I think that firstly, now Johan is correct that as a general rule, anything that's said and done in the mediation is confidential. But if I might say that those general rules in law are subject to exceptions. And there are a number of circumstances in which an exception like that could arise. In fact, I'm aware of a case in which exactly one of those exceptions came to light. And it was in these circumstances. Remember that those documents are only confidential by consent of the parties. And therefore the parties could reverse that position if they both agreed to. And what actually happened in this case was that one party filed court papers and referred to what happened in the mediation wrongly. The other party had an election as to whether to apply to have those allegations struck out, but elected not to do that, but to rather set its side of the story out for purposes that are, you know, for strategic purposes. And what then happened is that the contents of the mediation actually now, by consent of the parties, were no longer confidential. And they were also no longer without prejudice, because the parties had waived their right, their right to have that information being without prejudice. So in those circumstances, now suddenly what had happened in the mediation was before court, and there was kind of open season on that. So that rule fell away. So the point I'm making, Johan, is that although you are correct in general, one has to be careful in law. These laws are not cast in stone, and it's impossible to predict down the line what can happen. And I must tell you from my practice, one thing that you learn early and then you see that for years and years to come is human nature, and what happens is unpredictable. So that's why my earlier point was keep those. My advice is to keep those notes, but keep them safe and keep them confidential, for the simple reason that you never know what happens down the line. And it may be necessary for you to examine what happened. I've had experience as an advocate as well, where 3 or 4 years later, it became necessary and crucial as to what happened in a consultation that I would never have imagined would have come up. And I could produce accurate notes and explain what had happened was actually decisive in that case. So that the point I'm making is, yes, it is general rule, you're right. But my advice to you is if you make notes, make them accurate, be careful about the notes, and then preserve them, but keep them confidential.
Thank you, Ian. Henry, I want to thank you very much for your suggestion that SAMLA should write a recommendation or a guideline about this. And as the deputy chairperson of SAMLA and the person who wrote our code of conduct, and also as a major contributor to our MOI, Henry, can I ask you to write that? But I'm also going to ask Johan, who started off this whole bun fight, and Lee and Ian to give you their inputs on this topic, and then ask you to settle what. And I'm also not sure where it should be written, Henry, but you'll know best where it should be written. Is that in order?
That is in order. We may have to go and do some research in other countries, whether it's required of mediators to retain records.
Henry, are you volunteering to go on a sponsored trip to actually go and conduct this research on our behalf?
Thank you very much. How many countries can I visit?
Now, I'd like to see a professor who gets sabbatical leave, doesn't he?
Sorry,
now that Henry's a professor, doesn't he get sabbatical leave every now and then?
There we go. There we go.
But I dare not ask them for sabbatical leave at this stage, because I've only been promoted.
I just want to point out to Johan, is one of the problems of participating in SAMLA events is if you make a particularly relevant point, you get a job. So you've now got a job, Johan, to talk to Henry about this.
Will do.
Thank you, Johan.
Okay, Ashley, is it Dirk Pretorius the next question?
Yes, thanks.
Hi, Dr. Edling. I think one way to approach this, there is some sensitivity that I hear regarding mediators and the prospects of being sued. Most medical professionals are supposed to have professional negligence indemnity insurance. I think one of the options may be to approach the insurers, like PPS or AON or whomever these guys are, and ask them what is the position of a medical practitioner participating as a mediator and whether that is recognized as part of their profession under which they are covered. And I think the other thing to note is that
we didn't mention that, but that's a very important point. We do encourage all mediators to make sure that they have professional indemnity insurance. What I can tell you without mentioning any names is I have approached various of these insurers, and some of them do provide it and others do not provide it. But it is an important point. to make sure whether you're a medical practitioner or a allied health services practitioner or a legal practitioner, make sure whether your insurer does, and that they then list on your policy that you're a mediator as well. And if they don't, find one that does, and then consider your options. But it's important to have indemnity insurance.
Yeah, that is very good. And I think, also to note on Advocate Dutton's point is that if you put yourself in the front line, you should be expected to be shot at. So I think, it's very important to keep all notes, to preserve them for whenever they are needed.
Yeah, now my approach, Dirk, if I go to the front line and be shot at, I rather look at my shield and armor before I look at the doctor who's going to fix me up after I've been shot.
True, absolutely.
Any further questions?
I may just share this with you. I was taught many years ago when we were still called article clerks then. My principal said to me the following. He said, "My boy, you must remember one thing. Every client is a potential enemy." Now, the same principle, I think, applies to us as mediators in future. The disputants may not have mercy on us.
True.
Thank you. Ashley, I want to ask you a question now. There's a lot of richness in the chat function of this meeting, and a lot of questions have been answered there. Is there a way of making the recorded chat text available to the participants in the meeting? And I have seen some questions in that regard.
Yes, I can, as long as it wasn't any private conversations that happened. So basically, I can save my chat and format it into a format that we can send to everyone, and as well as the question and answer report. Yes. So I can do both and attach it. What I'll do is we'll have the recording, which, Ian, if that's okay, if we can put it onto the Prac Guide YouTube channel. Yeah. So that'll be available on the Prac Guide YouTube channel, and then I will just put links to uploaded the chat and the Q&A report. So that will all be available.
Ashley, can I then just say this, that what we'll do on the Prac Guide is, I think that during this week we'll send out additional content on some of the topics that have come up today. And we'll have a look at further information and training and that type of thing during the next few days, and I'm sure there'll be some developments there. There've already been some discussions. Lee and I will chat and what have you. But if they go to the Prac Guide and at least just click on the newsletter function, then they can stay in the loop, and we make sure that all communications go out via email to them if they click on that. It's a pop-up that comes up as soon as you go onto the Prac Guide. So I think that's the best way for them to stay in the loop with these things.
Perfect.
Thank you, Ian. Ashley, I want to ask you another question. Maybe you can and can't answer it. On Tuesday evening, we had a very big open meeting in which we informed people about the project, and we invited people to apply for participation. And there we showed people who are not in it how to get into it. Are there people in this meeting who were not there and who need information on how to apply for inclusion in the pilot project?
I will only be able to tell you after downloading the attendees report.
Ashley, can you just explain to everybody how to put up blue hands, and just ask if there are people now in this meeting who want to participate in the pilot project but who don't know how to go about it, to just put up your blue hand, because
I can see lots of people putting up their hands. So there we go.
Lots of hands. All right. So then I think let me just deal with that. I'm not going to take a long time, but I'm going to show you. All right. Thank you. You can put down the hand.
Okay. You can stop putting up your hands. Just one question. We had one person who had to leave, but asked a question, which I said I'd ask out loud and give a copy of the recording. So that's from Robin. Is mediation meant to be more cost effective than litigation? And if so, where is the saving as compared to court proceedings?
Okay, well, the answer is definitely yes. I'm going to ask Lee to give the proper answer.
Yeah, there's absolutely no doubt that mediation would be, if I can take a matter as an example and say we're dealing with someone who's had significant orthopedic injuries, possibly a brain injury as well. You're often dealing with 10 or 11 experts per matter, sometimes more. But in the RAF context, because we're dealing with future medical treatment by way of an undertaking, you could have 20, 22 experts per matter. If the matter doesn't settle, you often have these experts, or many of them at least, who would then have to come to court to lead evidence. So in a trial situation, you're going to have the cost of the attorneys as well as the advocates, as well as the experts. And sometimes you want your experts to listen to evidence of the opponents, so you've got that cost as well. There can be absolutely no doubt whatsoever that if one mediates, one is curtailing huge costs, because you may have an expert or two that you want to bring to the mediation. Very often that's not the case, though, particularly I would foresee in RAF matters. So you've got your mediator and you've got the parties. The parties can elect who to bring, but a mediation in an RAF matter, I suspect, is going to be seldom going to run over a day. As opposed to a trial situation where you can have a 9 or 10-day trial, you're then waiting for judgment for ages, so that's a time factor, but your costs inevitably have to be lower. I mean, there can be no doubt that they're going to be lower. I don't know if anyone else has anything to add there, but...
Yeah, Lee, I very much agree with that, and I think that we just remember that remember the tiered process. So some matters are going to settle without the need for mediation, some will be mediated, and some will go to litigation. But of those that go to mediation, and I agree with your assessment. I'm sure that look, maybe you need 2 days, but certainly a lot shorter than trial, because you can cut down on the numbers of unnecessary experts and lengthy evidence without the party, which the parties could actually agree on. So now, even with the additional costs of a mediator or even 2 mediators, if you look at the amounts involved, I'm quite sure that mediation is going to be far more cost effective.
Thank you very much. I see a question here from Jacqueline O'Brien, who applied to be in the pilot project, and she applied in March. Jacqueline, we do have your name. It was given to us on a list by Marianne Scher, and your name is included in our list for the next round. So the mediators that we've included and the observers so far, many of them are people who have been attending SOMLA mediation meetings since 2017 and 2018 and 2019. But Jacqueline, you are on our list and you are in the next intake. We can also provide maybe just a list of that so people know who are already in that next intake. But we have not yet scheduled that group of people into teams of 4. That will be another process. Let me then show you now to participate in the project if you have not yet applied. The first step is to register as a SOMLA registered medical mediator. So this is the SOMLA website. The URL you can see there is medicolegal.org.za. So if you go to the SOMLA website, and then in the top panel, you click on the tab Registered Medical Mediators. That then gives you this text, which you can read. That explains what it means and how you become a SOMLA registered medical mediator. But in short, it means you must be a professional person in good standing with your basic professional body. You must be a trained and accredited mediator. You must provide proof of that. And you must sign a code of conduct, and you must sign a pledge to mediate according to the SOMLA guidelines and protocol. So if you're already a trained and accredited mediator, you just have to provide proof of that, fill in the application form, and sign the pledge. So the application form is lower down on the page. There it is. You complete that form with your personal details. You answer all the questions here. And then paragraph 16, A, B, C, D, E, tells you which documents you need to submit to SOMLA together with your application. And these documents are then kept by SOMLA to confirm that you have actually proved that you are eligible to be registered as a mediator. There's an authorization, an affirmation, and a pledge. You sign and date the document, and you send it to that, info@samla.org.za. That is the SAMLA secretary, who is Mrs. Christa Koolewijn, as has been for many years. And you send that together with these documents that are specified here, and then you will be included on that register. So let me just go back there and show you the register, because everybody can see that as well. It's a public document. On the same tab, Registered Medical Mediators, there's a blue link there to say find a SAMLA registered medical mediator. So if you tick on that, it shows you all of them. We've got 3 pages. If we go to page 3, you can see that we have up to now 54 registered medical mediators for SAMLA. What I wish to show you is another thing, and for all SAMLA members, whether or not you are already on this register. When we go through the allocation process to try and get a balance of experience and authority, etc., in the team of 4 people, we search this register of 54 people by doing more specific searches. So if I click on SAMLA medical mediator and medical legal attorney, I click there, then I will get the names of the 4 attorneys who have registered. If I untick attorney and I tick medical legal advocate and search, I will get the names of the 8 advocates who are registered on this register. And if I tick mediator and expert witness, then I will get alphabetically the names of the 23 expert witnesses who are registered. But now you will notice that if you add up these 3 categories I've mentioned, that doesn't add up to 54. We've actually counted, there's 19 people who aren't accounted for by those 3 sub-searches. Now, the reason for that is the following. If we go into the SAMLA membership profile, if you open the website, you're a SAMLA member, you must log in. Okay, I'm not logged into this as an administrator. If I go view and I go to my name, because I'm not concerned about confidentiality of my personal details, but I'm going to go to my membership here, and I'm going to show that. So every member of SAMLA can go on the website, they must log in, and then they can edit their own personal details. So please go there and ensure that if you are an expert witness or a medical legal attorney or a medical legal advocate, that you have indicated that. Okay, so you see, I've ticked the box that said I'm an expert witness, but I'm not an attorney or an advocate. When you go to ticking the box, it doesn't look like this. It looks like this. There are 3 selection boxes. I've ticked yes for expert witness and no, no. So everybody who is a medical legal expert witness or attorney or advocate, please tick the correct box. Now, I know there are SAMLA members who do not fall into one of those 3 categories, and we are now asking the developers of this website to upgrade this to put another category in here for other. So if you're not one of those 3, then please click that other tab. And I know who that is. Most of the people who are SAMLA members but would come under the other tab are people who are mediators but who have not done medical legal practice as an attorney, advocate, or expert witness. So if you are an expert attorney or advocate, please tick that box. And as soon as we have the functionality of the other option there, then also just tick that box. So there I've shown you how to get onto this register. Now, when we select people to come onto the project, we select people from that register. The only exception to that is because of the assistance that Conflict Dynamics has given us for the past 3 years already in terms of our other pilot projects. We have accepted that people who are on the Conflict Dynamics list, but who do not for any inconceivable reason wish to also be on the SAMRA list, we will also accept. So we asked Marion, and Marion sure gave me a list of a certain number of Conflict Dynamics mediators. All of them have been included into our selection in the first group, the second group, and the third group. So if you're not on the SAMRA list, you have to be on the Conflict Dynamics list. I think it's better to be on both, because future clients of mediation will probably look at both places to find mediators. Then what is very helpful is a bioinfo document that Janae has sent to everybody who was at previous meetings. Janae, will you please also provide that bioinfo request to Ashley, so that when she emails everybody documents, that can be included, because that is essentially a document that helps us to understand how much experience do you have in medico-legal practice, how much in mediation, and if in mediation, what type of mediation it's been. So to complete that document is not essential, but completing that document does allow us to select you at an earlier point in the pilot project. So those are the steps. Thank you. Ashley, is there a further question?
No, I don't think so. I think we're done. Everything's answered.
Lee, any concluding comments?
No, Hannah, I think so much has been discussed. I've got nothing to add at this stage.
Okay, thank you. Ian, any concluding comments?
No, similar, just to say that it is very interesting. I'm sure these conversations will continue in the next few weeks.
Yeah. Thank you. Janae, is it clear what documents you must provide to Ashley?
Yes, she has all three. She has all three already.
I have everything. Just to make a note that email will only go out on Monday once we've edited the recording and put it up. So that takes a bit of time. And I'll send one email with everything, a link to the recording as well as all the documents.
Thank you very much. Henry, Professor Latham, any concluding comments?
I want to thank you and your team for a very industrious day. I learned a lot.
Thank you, Henry. JP Fenton, any comments? JP has
nothing. Thank you. No other comments. Just excellent information.
Thank you very much, JP. Brigitta, any comments?
No, thank you. I've just commented now. Thank you. It was an incredible session, and even just for general mediation, some of the things learned are applicable. So I really appreciate being part of this session.
Okay, thank you very much. Now, as we know in RAF litigation, the whole process of investigation ends with the industrial psychologist. So I think it's fitting for us to now conclude with a final comment from the industrial psychologist, Dirk Pretorius.
Thank you so much. I really enjoyed this. I think that, at last there is some structure into the industry that is getting a lot of momentum, which is a very good thing, setting standards and a framework of such going forward. I think that will be very beneficial to claimants, to represent them fairly in the process going forward. And personally, I think that what we're doing at the moment to not only speed up the process in terms of the settling of the claims, I think, personally, that, it's going to benefit a lot of parties, if we can get this going in a formal way. And if there's buy-in from people like RAF and other litigants in the country in order to get this process formalized. So I'm very pro what we're doing at the moment. Thank you.
Thank you, Dirk. So thank you to Ashley and Aslan. Thank you to all the panelists. And thank you to all the participants. This was a marvelous session for me, and I really appreciate your presence. Thank you and goodbye.